Hello, everyone, and good morning, and welcome once again to Uncivil Law. We tune in once again to the Karen Reed case today for motions hearings, including hearing the motion to dismiss, which of course will be denied by the judge, as we've sort of discussed, and other matters before the court relating to the ongoing proceedings. Of course, earlier today, the lawyers for Karen Reed were in federal court having a hearing there. And at the end of the stream, we'll try to go on Twitter and try to figure out a little bit about what happened relating to that stream, because unfortunately, of course, there are no cameras or audio from the district court. So we'll have to go to the Twitters and see what they're saying about it in terms of what happened and how substantive it got. And we can see what happens were there. Of course, probably no decision from the judge, I would have imagined. And we'll see what we're looking at in terms of the future. Thank you, Tracy Walker, for the 10 gift memberships. They are, of course, extensively appreciated. We are just waiting for this thing to start, which may or may not start at the top of the hour it's supposed to, but, we'll see how it's going to go. Good morning, Ellie. Good morning, Carol Ann. Good morning, Tony. Good morning, Tired Night Shiftner, Corey, May, Brian. Good morning. Glad to have you all here. And it is going to be a good day, I hope. We'll see if it gets as spicy as yesterday's hearing. Yesterday's hearing was awesome from the defense. Really great argument from the defense. Really good argument yesterday. So we'll see if they bring that same panache today. I don't know if they necessarily have as much to work with, but that won't necessarily prevent them from presenting good arguments. So we'll see how it goes. Good morning, Karen Lullen. Glad to have you here. Nanny, thank you for being here and spending some time with me. So we'll see how it all is going to go. We're also trying to figure out whether or not that dog bite expert's going to be allowed to testify. Also, there was a motion relating to a different expert that the defense was raising. They want to exclude. I'm not quite sure who that was, but there seemed to be someone else that was being talked about. Also, there is pending a motion that was filed, I believe, yesterday relating to changing the scheduling of the trial. So that might be discussed as well today. Thank you, Eddie Kramer. Glad that you love the content. Do try to provide some fun content, try to make it enjoyable. The meteorologist, of course. Yeah, I think they discussed the meteorologist as well yesterday, but I thought maybe there might have been another one that they were talking about in addition to the meteorologist. So that I might have been confused, but I thought maybe the defense filed a motion with respect to someone else beyond the meteorologist. So maybe that did happen, or maybe I misunderstood something, but yeah. Is the federal hearing before this? Yeah, it's related to the Karen Reed. It was a habeas motion, basically to preclude the case from going forward in state court. So yeah, the federal hearing was trying to prevent the state proceeding from continuing using federal double jeopardy law. And that was this morning. Yeah, the vet wannabe, maybe, yeah. Do I feel the judge is more on the prosecutor's side? Yeah, very much so. Very much so. In a way that I feel is gone beyond merely being prosecutorial friendly, because there are a lot of judges who are prosecutor friendly or defense friendly. But this is like love, right? It's gone beyond friendly into love. And that's not really appropriate. So Curly Gurley said yesterday defense also filed a motion to exclude the testimony of the dog behavior expert in addition to the meteorologist. Well, we heard about that motion yesterday. So yesterday they discussed excluding the dog behavior expert and discussed excluding the meteorologist. So that was actually discussed yesterday. So I thought that maybe there was another one on top of that had not yet been discussed. But again, maybe I misunderstood something. So, will she grant the gag order? Maybe. We'll see. Probably, if I were a betting man. Yeah, prosecutor is the golden child that can do no wrong, basically, yeah. Trump was forced to $2 billion to U.S. aid contractors. I saw the headline from the U.S. Supreme Court denying the injunction or overturning the injunction or whichever. So I saw that. We'll try to get into that at some point later. But it's injunctive relief, so it doesn't necessarily go to the merits. But yeah. Did I see the Supreme Court ruling on U.S. aid? I saw the headline. Denying the injunction. Today is the dismissal. I think that's principally what's being discussed today is the dismissal. But of course, it may go beyond that. We'll see. Did I see the soft sit in Judge McBurney's court? No, not really. Soft sits just drive me crazy. I just can't deal with them. I just cannot deal with soft sits. I cannot. I know too many things. I know too many things, and I can't deal with it. You don't know what habeas means? Habeas corpus, it's part of the Constitution. Basically means it literally means produce the body. What it means in practice is why am I being held or why am I being prosecuted? Right? I shouldn't be held. I shouldn't be in prison. I shouldn't be prosecuted. You know, produce me in court and justify why you are going after me. That's what habeas is. Yeah, 5 minutes of soft sit Schadenfreude is good, but only so often. I can't deal with it. It just gets my blood pressure going. DS has been a member for 28 months. Thank you. This case gets your blood pressure going. I feel that, Tony. I feel that. A lot of reasons to get your blood pressure going about this case, too. Are soft sits just trying to argue common law? No. They're trying to argue the law doesn't apply to them. They're trying to argue that they're not bound by the law. And I cannot be bothered to deal with their stupidity. Do I have any inside info on what's going wrong with Karen Yax? I have no idea who that is. I don't know who Karen Yax is. Who is that? So since I don't know who it is, I'm going to go with the presumption that I don't have any inside information since I have absolutely no idea who that is. It's KURT. Critical K? Okay. I have no inside information relating to that. Yeah, we'll cover the Supreme Court thing later. The pot from my houseplant has horizontal stripes. That means it's an Admiralty stream. Something like that. Frenchie's mom, thank you for being here. You have GB in your name, but you're French. Netherlands. Always good to have there. Good morning, Law Near JM. Hope you're having a good day. My dogs are Frenchies and my initials are JB or GB. Fair enough. Good morning, Kestrel. MJ Spidey, Texas. Yes, gotta love some Texas love. Holla. Curly Girly, why is the defense continually getting slammed for misrepresenting the court, yet Commonwealth is not getting a miss for doing the same thing? Wouldn't this be grounds for appeal? Potentially, yes. But bias is a difficult argument to make in an appeal. Bias is a difficult argument, but it's potentially grounds for appeal that there was undue bias. That's a challenging argument to make. Neo Dark Matter, morning all. Good morning to you as well. There are not many easy arguments to make on appeal. Usually appeals do not lend themselves to really easy arguments. Because if they were really easy, then the district court probably would not have done the mistake, right? Like if it was a super clear thing. I mean, it does happen. It does happen, but it's the exception, right? Like normally, like their appeals are hard because normally they don't mess up in a really obvious, really clear, really legally wrong way, right? Usually you're looking for, kind of scrapes, and it's difficult. So, DS, thank you for the 5 gift memberships. The judge left the courthouse and got pulled over and blew a .325. That might show the judge was incompetent at the time that they were hearing arguments. That might do something. Yeah. Can I do Marbury versus Madison? Pretty sure I've discussed it already on stream. I'm pretty sure I have a video on Marbury versus Madison. Check my channel for that. Facial hair is coming in nicely. Thank you very much. I keep trimming it, to make it look nice. Well, thank you. Still waiting for this thing to start. Now they're 4 minutes late. Good morning, Amber. Would I ever move to Boston? Not particularly, not strongly inclined to do so. I love it here, but the circus has made me sick to my stomach whenever it comes up. I was arrested for something I didn't do back in 2018. It's so triggering. If you were covering Brady versus Maryland's appeal, would you be pessimistic? Well, you mean like in the first instance? Probably. I mean, I don't know enough to know the full posture of Brady versus Maryland before it went to the Supreme Court. So, I mean, I couldn't really say how optimistic I would have been or not in that case. In order to answer that question, I'd have to have a really good understanding of exactly what the legal posture was but as Brady was bringing his argument. So, in order to assess Brady's probability of winning in Brady versus Maryland, I would have to understand the legal posture of the law as it existed at the time he was making those arguments. So I don't understand the law well enough at that time. I know what the law is now, obviously, but I don't know what the law is then. So I can't really answer whether or not I would have been pessimistic with respect to Brady because I don't know enough about the legal posture exactly as it sat at that moment in order to be able to assess the probability of Brady winning. So I can't answer that question. How do I think this case with the same corruption, different state would play out? Would it have never gone to trial? If it's the same corruption, then presumably the same result. Why would the state matter? Right? I mean, why would it matter what state we're in if it's the same corruption? I don't understand really the basis of your question. I don't understand the differential. And a different judge, but the same corruption? See, I don't understand what the difference you're asking is. If it's the same corruption, is the judge also corrupt? I don't understand what you're asking me. So could you clarify your question? Does U.S. Border Patrol need a warrant to enter your house if you're within 20 miles of border? Yes. You shouldn't have said same corruption? Okay, clarify your question then and re-ask it. Yeah, Dr. Wolf, the neurosurgeon. That's right, Karen. Yeah. The second expert witness they're trying to exclude was Dr. Wolf, a neurosurgeon, who wanted to opine on the cause and manner of death and hardness of ground. Yeah, Dr. Wolf, I think that's right. Yeah. I think that's right. So that was the other expert they were trying to exclude that they mentioned. We could try to read the U.S. Supreme Court while we're waiting. I'll probably get interrupted by... But we'll discuss this while I'm waiting since I need some content. Do I think there should be changes in how judges and DAs are appointed? DAs are elected, not appointed. In terms of judges, whether they should be elected or not, that's an interesting question. I'm not sure it really makes that much difference, to be honest. How would I compare the corruption in this case versus Murdaugh? I don't really see corruption in Murdaugh. I don't really see corruption in Murdaugh, I don't think. So I'd have to say that the corruption in Karen Reed is much worse. Well, Beverell and any of this trial before trial, probably. Yeah, the only real corruption was the interference by Becky. Yeah, which isn't really corruption, just so much as being completely bonehead stupid. I'm trying to find this Supreme Court thing that they did today. I'm trying to find it, and I can't actually find a copy, which is annoying. Oh, Lord. Okay, here it is. Here it is. All right. Department of, this is 9 pages. We're probably not going to be able to make it through, but we'll try to read this a little bit. On February 13th, United States District Court for District of Columbia entered a temporary restraining order enjoining the government from enforcing directives, policy, and disbursements of foreign development assistance funds. The present application does not challenge the government's obligation to follow that order. Okay. On February 25th, the district court ordered the government to issue payments for the portion of the pause distributions, those owed for work already complete before the issuance of the district court's temporary restraining order. Several hours before the deadline, the government filed the application to vacate the government's application. The Chief Justice entered an administrative stay shortly before 11:59 deadline and subsequently referred the application. The application is denied. Given that the deadline in the challenged order has now passed, and in light of ongoing preliminary injunction proceedings, the district court should clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order, with due regard to feasibility of any compliance deadlines. The order is hereby entered by the Chief Justice is vacated. So if I'm understanding this correctly, this relates to payments for services that have already been completed. So like people have already done services and they want to get paid for the things they've already done. So that makes sense to me. Like, right, we owe them the money because they've already done the work. So if that's right, because that's what they're talking about. Yeah. The district court ordered the government to issue payments for portion of the pause disturbance, those owed for work already complete. So yeah, that makes sense, right? People already did the work, they're entitled to get paid. So that makes sense to me. All right, then we've got some dissenting votes. Does a single district judge who likely lacks jurisdiction have unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to the question should be no, but a majority of the court apparently thinks otherwise. I'm stunned. This gets into a broader issue, by the way, which the Supreme Court really needs to deal with, which is these universal injunctions and the effect there too. And I'm not necessarily surprised the Supreme Court didn't do anything about it like right now, but they really need to at some point. They really need to clarify what the rules are with these universal global injunctions. Someone needs to figure out what the rules are. All right. Anyways, in capsule form, this is what happened. Response to our group of American businessmen and nonprofits that receive foreign assistance funds from State Department and USAID. They brought suit and claimed that the current administration's temporary pause is unlawful. On February 13th, the district court entered a temporary restraining order requiring the government to halt its funding pause. It based that decision on finding response are likely to succeed in showing the government violated the Administrative Procedures Act, which is a law that, is a huge deal in this domain as it relates to agencies. And USAID is an agency. And so the Administrative Procedures Act is a huge deal, and that makes sense to me. After issuing the TRO, the district court grew frustrated with the pace at which funds were being distributed. And on February 25th, he issued a second order requiring the government to pay out approximately $2 billion. The government brushed aside the government's argument that sovereign immunity barred enforcement, and he took two steps that, unless corrected, would prevent any higher court from reviewing and possibly stopping the payments. First, he labeled the order as a non-appealable TRO. I didn't even know that was possible to have a non-appealable TRO, because a TRO is an injunction, so I didn't even know that was possible, but okay. And second, he demanded the money be paid within 36 hours. This left the government with little time to try to obtain some review of what regarded as a lawless order. The government moved for a stay pending appeal in the district court, but the judge shrugged off the government's sovereign immunity argument and ignored the government's representation that most of the money in question, once distributed, could probably not be recovered. I mean, yeah, once the money's gone, it's going to be a little bit hard to get it back, right? Rule 1 of rules of acquisition, right? The government quickly filed appeal to the United States Court of Appeals for District of Columbia. With only 4 hours to spare before the payment deadline, the district court dismissed the government's appeal because it took the district court's TRO label at face value and claimed it lacked appellate jurisdiction. With nowhere else to turn, the deadline fast approaching, the government asked for this court to intervene. At the last moment, the Chief Justice issued an administrative stay. Cool. Unfortunately, the majority has now undone that stay. As a result, the government must apparently pay $2 billion post-haste, not because the law requires it, but because the district judge ordered. As the nation's higher court, we have this duty to ensure the power entrusted to federal judges to the Constitution is not abused. All right. Time does not allow a lengthy discussion of the legal issues presented, but a brief summary suffices to show the district court's order should be vacated or at very least stayed. To start, it's clear district court's enforcement of the order should not be construed as an appealable preliminary injunction, not a mere TRO. Yeah, I tend to agree. A TRO, as the name suggests, is temporary. Yeah, it's like it just puts things in place. It really shouldn't have permanent impacts. A TRO should not have permanent impacts. A TRO, as its name suggests, is temporary, and its proper roles to issue restrained whatever. This is still going, right? Great, messing on. All right. The order here, while commanding to pay the vast sum that in all likelihood can never be fully recovered, is no sense temporary, nor the order merely restrain the government's challenged action in order to preserve the status quo. Rather, it acts as a mandatory injunction requiring affirmative action. Right. And given its likely irreversibility, the district court's enforcement order effectively gave respondents a portion of the ultimate relief they seek. For these reasons, the Court of Appeal had jurisdiction to consider the appeal, and we have jurisdiction to review. I have no problem with that, right? So it's like the district court called it a TRO, but it's not really a TRO. The label is not the thing. The label is not the thing. We don't really do law by magic words. So just because you called it a thing doesn't mean it is that thing. And the Supreme Court's like the district court called it a TRO, but it wasn't really a TRO. I'm like, yeah, that makes sense to me because it has permanent impacts, because it requires you to give money that you can't get back. So it's not really a TRO. That makes sense. Tracy, I do federal appellate work. And if you need help in the Fifth Circuit or the U.S. Court of Appeals or the U.S. Supreme Court in particular, let me know. Even if the majority is unwilling to vacate the district court's order, it should at least stay the district court's enforcement order until the government is able to petition for a writ of certiorari. In considering whether issues such as stay, we ask at a minimum, where the moving party is likely to prevail on the merits, and where the moving party is likely to suffer irreparable harm. In close cases, we also take into account other equitable considerations. Here are the factors weigh in favor of say. Likelihood of success. The government has shown likelihood of success on the merits that sovereign immunity deprived the district court of jurisdiction to enforce the order. Always something you need to consider when you're talking about the government. Dave Hill says the effects of the TRO may be permanent, preventing illegal activity in the interim, but when the TRO involves continuation of the payment system, those payments are still part of a TRO. I disagree. And so does the U.S. Supreme Court. So I disagree. Sovereign immunity bars a suit by a private party seeking to impose a liability which must be paid from public funds in the Treasury. But exactly what the district court ordered to do here. Yeah. Sovereign immunity may be waived, but to sustain a claim the government is liable for award of money damages, the waiver of sovereign immunity must extend unambiguously to the claim. Attempting to satisfy this strict requirement, respondents proved to APA's waiver of sovereign immunity for certain actions seeking relief other than money damages, which is exactly what they're seeking because they want money. The language, as we explained, distinguishes between specific relief, which is permitted under the APA, and compensatory substitute relief, which is not. But here the relief more closely resembles compensatory monetary judgment rather than order for specific relief that might be available in equity. An injunction to compel the payment of money past due under a contract or specific performance is not typically available in equity, or a specific performance of a past due obligation is not available in equity. Yeah, that makes sense. Sovereign immunity thus appears to bar the sort of compensatory relief the district court ordered here. Hoping to escape the conclusion, respondents point to Bowens versus Massachusetts. In that case, we held APA's waiver of sovereign immunity covered district court's judgment reversing a final order of the Secretary of Health and Human Services refusing to reimburse Massachusetts for certain Medicare expenditures. Unlike the district court's order here, that judgment did not purport to order that any payment be made by the United States. Rather, Bowen simply recognized a basic reality of APA review. After the court set aside an agency action, a natural consequence may be the relief of funds to plaintiff down the road. Indeed, we have clarified since that Bowen has no bearing on the unavailability of an injunction to enforce a contractual obligation to pay past money due, the sort of relief that appears to have been ordered here. Lois Thomas gifts their membership. Thank you very much. Have I ever seen a change in that a hung jury is acquitted since government's not met their burden? No, I've never seen that. The district court, however, failed to mention must less reckon with Bowen or Cudson before applying ahead with $2 billion, nor to take account of our previous suggestion that proper remedy for agencies' recalcitrant failure to pay out may be due to seek specific sums already calculated and passed due in court federal claims. That most can be said is the district court's denial of the government's motion for stay pending appeal. It cited but did not analyze a head full of cases echoing Bowen's discussion of APA's conscribed waiver of sovereign immunity. One might expect more care from a federal court before it so blithely discards sovereign dignity. Finally, the government has a strong argument that district court order violates the principle the federal court may not issue an equitable remedy that's more burdensome to the defendant necessary to redress. In this case, the district court's enforcement order functions as a universal injunction defying foundational limits on equitable jurisdiction, which always is a problem that needs to be addressed at some points. What do I think about the judge's questions from today's hearing? I don't know what you're referring to. I don't have any clue what you mean. The district court ordered the judge to pay all invoices and letter for credit drawdown on payment contracts for pre-TRO work completed. That order encompasses more than just respondents, and district court offered no reason as to why universal release to the parties is appropriate here, and thus not the sort of case which only universal relief is feasible. Even supporting the APA's claim allows universal vacatur of rules in some circumstances. The district court's order of direct monetary payment bears no resemblance to that. And nobody suggests the government is unable to identify respondents allegedly owed funds and pay out only to them. Limiting scope of relief in that matter would be significant. Below, the government responded seeking roughly $250 million, still a large figure, but a fraction of $250 of the $2 billion ordered. Harm to the parties ordered. The government has shown that it's likely to suffer irreparable harm if the district court order is not stayed. The government has represented that it would probably be unable to recover much of the money after it's paid because it would be quickly spent by the recipients or distributed third parties. Respondent did not credibly dispute this representation, and the district court does not find it to be factually incorrect. Thank you, Alan Parker, for the 20 gift members. Someone posted to Twitter on federal court. I haven't got into it yet because we were going to cover relating things to the federal court after the state proceeding. That was the plan. So I haven't gone to anything relating to the federal court yet today. And at the moment, I'm in the middle of reading this. Would you like me to switch? I guess I can, if you'd prefer me to do that. All right, give me a second and let me see if I can pull up Twitter, and we'll go to X and do that instead. Did I go over defense motion to exclude Wolf? No, I have not. All right, let's see. I can only do one thing at a time, guys, amazingly enough. So, you guys got to pick, right? All right, let's see what was going on in this thing. All right. So let's try Karen Reed is innocent. Karen Reed updates channel. Let's see if they have anything relating to today. No, nothing there relating to that. So they don't have anything. How about Free Karen Reed? Do they have anything relating to this? No, they don't have anything relating to this. Okay, great. So none of the channels I usually follow have it. Okay, fine. I am now just doing a search for Karen Reed and trying to see if anyone is discussing it. No, 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 still no, still even no, still incredibly no, 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 still no, still no, still no, still no, no, still no, 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 no. J.M. Lawrence at the top. That doesn't relate to the federal proceeding. That's something completely different. Are you just saying it's on their channel, generally speaking? All right. So let's see. All right. So I have to do this in reverse order. That's fine. All right, so let's see. All right, Karen Reed sitting at counsel table next to her lawyers in the large courtroom. The federal judge is on the bench. Basically, a federal constitutional question. He'll consider it de novo. Fair. Reed's attorney opens, I believe strongly the court should establish a precedent that the right to post-trial voir dire is an essential part of double jeopardy. No way. In essence, the state judge should have investigated the jury's findings. The judge has to explain what would give him the power to probe what happened in the jury room. They cite constitutional grounds. Not a chance. The acquittal is not the announcement. It's not the finality of the verdict. It's the decision of the jury. Here we have powerful evidence the jury acquitted, and state's decision is so what cares. He notes that none of the other 7 jurors have voiced any opposition, and I continue to take exception to that argument. I don't like that argument. I don't like it at all. Weinberg urges the federal judge to call the Karen Reed jurors in his courtroom where there are no cameras and question them. Is there precedent for a federal court to require voir dire of a state court? There's none for a double jeopardy contention. Yeah, I don't think there would be. Yeah, that's not going to happen. Reed attorneys Alan Jackson and David United are sitting on the back bench in federal court. Reed's other attorneys are sitting in the gallery. There are empty benches, only a handful of spectators. Many Reed supporters decide to stay away in deference to the seriously, tightly constrained culture of federal court proceedings. I don't even know what that means. What does that mean? They decide to stay away in deference to tightly constrained culture. What does that mean? I don't know what that means. What the hell does that mean? Federal proceedings are open to the public just like state level proceedings are. You can go watch. What the hell are you talking about? What the hell are you guys talking about? Nothing prevents Judge Saylor from doing some fact finding, they say. I think there is. There's nothing more important than a double jeopardy clause. This case cites for some decision making in an area that hasn't had a great deal of decisions. There's been a lot of decisions in this area, just not in the way that you want them to be, unfortunately. Judge Saylor has some factual questions. He wants to know how much the fact findings the SJC did and whether he's required to give deference to their findings, which is a question I also had incidentally as a lawyer. I was also a little bit like, I said this much on the stream, I'm a little bit not 100% clear exactly whether or not these are findings of fact or findings of law, and am I stuck with them as a federal judge? So the federal judge is also not 100% sure whether they're stuck with them, which validates me. Like, it's nice to know that both I and an actual sitting federal judge are both a little bit unclear about whether or not they're stuck with it, right? It's like, oh, okay, we're both a little unsure. That's nice. Weinberg describes some of the factors that led the Supreme Judicial Court declaring the judge had manifest necessity to declare a mistrial. Defense disagrees, contending judge deviated from prior practice by not talking defense or prosecutor before declaring mistrial. They argue they didn't seek alternatives. She should have asked the jury if there's unanimous decision on any counts. That she could have. She could have. That's the problem. Yeah, she could have. She could have. Did she have to, though? That's the problem. Does the argument require I ignore what happened with the first and second notes? Responds, the dialogue surrounding those notes shows defense wanted a verdict, not a mistrial. The judge's prior practice was to read the note and consult. She deviated at the last minute and declared game over. Yeah. Simply put, superior judge erred. Even if that's true on manifest necessity, you still have the problem of consent. I think Karen Reed might very well be able to win on manifest necessity. I don't think that's the problem. I think she can win on the federal court on manifest necessity. The bigger problem for her, in my view, is the issue of consent, whether or not she consented or waived the issue. That's the bigger problem. If jurors' post-trial claims are found true, there's no manifest necessity for mistrial on all counts. Which I don't even know if that's true, by the way, because that also presumes, that part I don't know is true, because that presumes the judge is required, as a matter of the federal constitution, to accept partial verdicts, and I don't know of any case that says that. I don't know of any federal case, and remember, we're in a federal court on federal law, right? So I don't know of any federal case that says if the judge says, okay, what's your verdict? And they say, okay, we're not guilty as to count 1 and 3, but we don't know about count 2. I don't know of any federal case that says the judge can't say, well, I'm just declaring a mistrial across the board. I don't know of any federal case that says that. So in the absence of such a case, I don't know that that argument makes sense. The Commonwealth strongly rejected Karen Reed's defense argument. Judge did not consider alternatives to mistrial, citing her actions in response to first notice where she encouraged consensus. The state attorney argues no inkling the jurors' notes of agreement on any charges. And even then, I don't know that she necessarily had to, because even if it had provided that inkling, the rule only, even the state level rule only says may. And we're in federal court anyway, so the state level rule doesn't matter. You know? Federal judge says he's wrestling with his role, says he must accept the Supreme Judicial Court's interpretation of state law, which is absolutely 100% true, and show deference to factual finding. He calls it somewhat fuzzy. Again, it's somewhat validating that both me and the sitting federal judge, confirmed by the U.S. Senate, are both also slightly unsure on this issue. Right? We're both a little unsure about exactly the degree to which we're stuck with certain representations. For example, the Supreme Judicial Court saying the judge considered alternatives and considered the alternatives. Is that a finding of fact? It might be. Is the federal judge stuck with it? He might be. And the federal judge is also a little unsure about whether they're stuck with it or not. So that's validating to me, right? We're both a little unsure. Great. The Commonwealth responds by saying it's clear the Supreme Judicial Court's view must control. Okay. The Commonwealth argues Massachusetts law requires a verdict must be read aloud in court or it doesn't count. The double jeopardy clause of the U.S. Constitution does not go so far as to say the state cannot impose that requirement. Fair? He says a juror could change their mind about other counts right up to declaration of court. It has happened. That's true. And we've actually seen it happen, right? So, right up to the moment they're asked and they're polled, they can change their mind. That too. Reed's attorney, Martin Weinberg, gets to respond to Commonwealth, says law does not bind the federal court from looking into the record. Well, it doesn't prevent them from looking into the record, but it might bind them as to what they find once they look. Weinberg cited a long list of cases he says supports his argument. State law does not govern when state law conflicts with the double jeopardy clause. We all know that. We all know the federal law obviously wins when there's a conflict. No one disputes this, right? But exactly what the federal law is in this domain is, of course, as always, the issue, which might include, for example, the federal court being bound by certain representations or certain conclusions by the Supreme Judicial Court. Those might be findings of fact. So no one disputes, right, that the double jeopardy clause of the Constitution overrides anything the state wants to do. Of course, the issue, as always, is what exactly is the federal law on this issue? That's the problem. The judge says they'll issue the opinion as quickly as they can. So basically, they had a completely so basically, it turned into what I thought it was going to be. Yeah, basically, it turned into what I thought it was going to be. This was basically my prediction, and I said as much. I said I thought that this hearing was going to basically turn into the merits, and that's exactly what it turned into. It turned into the merits. Basically, they had the merits discussion, and it sounds like the judge is ready to make a decision based on that, and that's exactly what I expected to have happen, especially given the time frame, right? Especially given the time frame. So they had their argument. That is all the argument they get, and the judge is now going to make a decision, right? That's exactly what's going to happen now. Cool. Great. The judge says it's wilderness. It's a thick forest anyway. It's a little thick at times. It's a little thick at times. So the judge and I seem to be thinking along similar lines as closely as I can tell. As closely as I can tell, the judge and I are thinking about this along the same lines. Based on this very reduced representation of the questions that were asked. But yes, that seems to be, although interestingly, nothing in that exchange talked about the issue of consent, which is interesting to me because for me, that's the more, it's the most interesting issue for me as the judge. And nothing in that exchange even apparently talked about consent. They were just stuck on the issue of manifest necessity, which is interesting to me that the judge apparently didn't give the issue of consent. Because for me, that's like, you know, as you're thinking about a judge or even as an attorney, you're like, water goes to the lowest level, right? Or like water goes to the lowest level. So you try to find Like you try to find the ground that is the easiest resolution, right? That's always what you want to do, right? How can I win, and how can I make it as easy for me to win as possible, right? What is the lowest level ground for me to win, all right? And if I'm the judge, win in this context is me making the legally correct decision. That's what a win looks like for me, right? Me winning isn't deciding for either party. Me winning is making the legally correct decision. That's what a win looks like for me as a judge. So for me, the easiest ground for me to win is the issue of consent, because if she consented or waived, then it's gone. And so that, I think, is the easiest ground. But at least according to this recording of the thing, they never discussed the issue. And I don't know what that means. I don't know what that means. Maybe the judge disagrees with me on this issue, which would be interesting. Like, because I'd be interested on that. Maybe the judge just thinks that consent is not. Maybe the judge just thinks that there's no consent, and it's clear there's no consent. Maybe that's what the judge is thinking. It's clear there's no consent. And so if the judge thought it was clear there's no consent, then obviously you move on to the next thing, which would be the manifest necessity. And we'll go argue about that for a while. But if the judge thinks that consent is that clear, if that's what they're doing, if they think it's that clear, I'd be interested to know why they think it's that clear. Because I always find it interesting when people disagree with me. I want to know why, so that I can reassess my own thinking. Because my thinking could be wrong. I'm not God. And I want to know what their thinking is and why they think certain things, so I can reevaluate. You know, that's what I think. That's what I want to know. So interestingly, they didn't seem to even mention the issue that I think is perhaps the most important. And I find that fascinating. But the judge does seem to share my interest in determining the degree to which they're bound by certain things by the Supreme Judicial Court that might in fact be findings of fact. For example, that the judge did do sufficient considerations of alternatives. They did do that. Is that a finding of fact? Am I stuck with that? If I'm stuck with that, then there's no manifest necessity. If I'm stuck with that representation, then I'm screwed. Then Karen Reed is screwed. Right? If that's a finding of fact, then I'm stuck with it. Karen Reed is screwed. If it's a finding of law, then I can reevaluate it. But I'm not sure which it is, and neither is the judge. The judge isn't 100% sure whether it's an issue of law or an issue of fact. So I appreciate the judge is also equally vague on this issue at the moment. That makes me feel validated. All right. So I suppose that will get us out of Karen Reed for a while. Let's return back to the U.S. Supreme Court. Wouldn't it have to be ruled on before April 1st? Or an injunction would have to be ordered before the 1st, one of the two. Presumably. It'd be really weird if the trial was allowed to go forward and then the judge issued a decision. That'd be weird. So presumably before April 1st, the judge is either going to reach a decision or issue an injunction or a stay to prevent the state court from proceeding while it tries to figure out what's happening. And then, of course, one would presume that the judge rules against Karen Reed. They're off to the Court of Appeals to see what they have to say. All right, so let's see what's going on. We return back to this dissent on the issue of the USAID thing. We usually balance the equities and weigh the relative harms in close cases. For the reasons I've explained, this is not such a case, and our analysis could end there. Nevertheless, respondents' equitable arguments are insufficient to justify denial stay. They contend failure to pay the money is a question that caused irreparable harm because without those funds, they could not continue to operate or would have to reduce the work they do. As a result, they claim recipients of their services would suffer. These potential court consequences are, of course, serious. But any harm resulting from failure to pay amounts the law requires would be diminished, if not eliminated, if the Court of Appeals had promptly decided the merits of the government's appeal, which it should not have dismissed. If we sent this case back to the Court of Appeals, it could still render a prompt decision. If it decided in favor of respondents, government would be obliged to pay all the money that's due, and respondents would have suffered only a short delay in receipt. And the government prevailed on the sovereign immunity argument, neither respondents nor any of the recipients of their services would suffer any unlawful consequence because the government's immune. In sum, the factors we decide in staying whether issued weigh strongly in relief. Today, the court makes an unfortunate misstep that records an act of judicial hubris, and again, this systemic issue is for me like the issue that most cries to me. In some ways, I don't care as much legally about this immediate problem as the bigger issue, which to me is the issue of, again, of district judges, and there are 94 districts. There are 94 districts in the United States. So any one of these 94 districts can issue an injunction with nationwide impact and global impact and universal impact. And I find that problematic. I'm not saying it shouldn't be the rule, but I have questions. And one of these days, the US Supreme Court really just needs to clarify what the rule is. Just pick something. Pick anything. Just let us know for sure what the rule is, because right now it's been just made up, right? This whole thing about universal injunctions basically has just been made up completely by the district courts. They created it out of nothing, and there's nothing wrong with that. There is nothing wrong with that. Judges have to create new law. That's one of the things they do with their time. We live in a common law system. So the judges had to make something up. That's what they do sometimes. Sometimes judges have to make something up. There's nothing wrong with that. But what there is a little bit wrong with is it's been like 60 years, depending on how we count, about this. 50, it's like a little bit, when exactly did this start is an issue of debate, 60s, 70s, whatever. So it's been 50 or 60 years exactly. And like the Supreme Court has never just said, okay, like I appreciate that you guys are trying to figure out the rule, but here is the rule. Just tell us what the rule is, please. Just tell us what the rule is so we all know what the rule is. Instead of like this, it's been a while. Could you clarify this now and like codify this a little bit? That'd be great. I'd really appreciate it, please. And impose a $2 billion penalty on the taxpayers. The district court has made plain frustration with the government, and respondents raised serious concerns about non-payment for completed work. But the relief ordered quite simply is too extreme a response. A federal court has many tools to address a party's supposed nonfeasance. Self-aggrandizement in jurisdiction is not one of them. I chart a different path, so I must fully dissent. Well, I will say this. The majority did not really explain its reasoning very well. The majority was like one page, and the dissent took like 8 pages. So, and the majority opinion, well, it's really not even one page. It's one paragraph. It's a paragraph. It's a long paragraph, but still it's a paragraph. And they don't really in there contend with the issue of sovereign immunity at all, which seems like, maybe you'd want to mention it. So the majority analysis is just like, And the dissent's like, but how about all these issues? The majority doesn't seem to really have any response. So I think on balance, I have to agree with the dissent just because the majority, if they're right, didn't explain why they're right. And also the APA dealing with non-monetary damages. Obviously, this is monetary because we're giving money. And they explain that position too. So I have questions. I have clarifying questions. Would I want to be a judge? I'd love to be a judge, preferably appellate judge, because I prefer law as to facts. So I know it's a bit of an ask, to be elevated to the Court of Appeals. I know that's a bit of an ask, but that's what I prefer, because trials are about facts. Who did what to whom, and is this witness credible, and all that stuff, right? It's all that messy fact stuff. It's like who's what and who's credible, and what are the facts, right? Trials are about facts. It's messy. I don't like it. It's just like, you just tell me what the facts are and I'll figure out the law. That's what I want to do, right? That's where I just got to go play chess in my mind with legal doctrine. That's way more fun. So I'd prefer to be an appellate judge. I don't want to figure out facts. I don't want to figure out facts. I don't want to. Just tell me what the facts are. Let me focus on the law, man. Is that an elected position? In Texas, it is. In Texas, it's elected. I think you have to be a lawyer for 4 years, though, in Texas. So maybe someday I'll run. We'll see. All right, let's look at watches for a while because I have nothing else to talk about while we're killing time. It's time to talk about watches. It's watch discussion time because that's what we're doing right now. All right. So this one I saw was pretty interesting just because it's technologically cool. I'm not really sure I like the styling of it or the way it's laid out. It's a little busy, but I do like this technologically because it's just really cool. So this is a Citizen. It's an atomic it's solar powered atomic set, so it's radio controlled moon phase. That is just technological, and it's the first one that's ever existed. As far as I can tell, it's the first one that's ever existed. It's a solar powered, so the battery will run for like 15 years. It's radio controlled, so it automatically sets itself. The watch sets itself to the atomic clock, and it's a moon phase. And so you don't even have to wonder what phase the moon is in because it automatically determines itself from the time and then readjusts the dial to set the moon correctly. That's cool. That's cool. That's just technologically really, really cool. Now, I don't really like a lot. I don't really like this sort of thing at the top, the way they've done the date. And like there's also a thing to determine whether you're in the south or north because the moon phase depends whether you're in the northern hemisphere or southern hemisphere. But there are ways to do that without putting on the dial. I've seen like they can do it where you like have a marker on the like bezel, and then you just you put the stopwatch position there to indicate which one. So you don't have to do it this way. I don't really need a full or empty indicator. I don't really understand the purpose of a power indicator really on solar watches. They'll run for 6 months in the dark. They'll run for 6 months in the dark, right? It's like, why do you need a power indicator? Right? I mean, what value does it have? I don't know. And then also they have this AM PM thing, which I could kind of do without. It's like I can probably figure out whether it's AM or PM. I'm not cave diving somewhere, but it's made out of titanium, and it's made out of titanium, and there's a stopwatch, and that's just cool. So that's technologically cool. Yeah, the full and empty is for the power reserve. Yeah, the full and empty is for the power reserve, not the moon. Right? The moon phase is the moon. That is the moon phase. It shows you a picture of the moon. That's how you know what moon phase you're in. It gives you a picture, right? That the full or empty is for the power reserve, and I don't ever quite understand it on a solar watch. Because why do you need a power reserve on a solar watch? I don't know. Right? I mean, a mechanical, like the best mechanical watches have a power reserve of like 5 days, right? It's like, so why do I need a power reserve indicator on a solar watch when it will run in darkness for 6 months? Why do I need a power reserve indicator, man? I don't need it, man. It seems like something I don't need in my life. Yeah. Yeah, it's a full-blown blizzard, man. I mean, you can charge it on artificial light. Okay, is there light in your house of any description? Are there lights on? If so, your solar watch will get enough power. I mean, it's ridiculous. But it's technologically very interesting, and I think that's cool. So that is a watch maybe someday. I don't have $680, but maybe someday I'll buy it just because I think it's cool. It's technologically cool, and I'm here for it. All right, let me show you the watch that Nate the lawyer just recently got for me. He originally bought me an Apple Watch. I'm not an Apple Watch guy. And then I did a little commercial thing for him, and he was going to pay me $100. And he's like, well, if you give me the Apple Watch back, I'll just buy you the watch you want because, basically be a roughly equal value. I'm like, okay, cool. That makes sense. So let me show you the watch that he got me. It's not a lot. It's a very cool tool watch. It's a very cool tool watch. And it just does kind of what it says on the label. So this is the one he got me. This is reference number BN0241-59W, if you want to look it up yourself at home. This is the Citizen ProMaster Tough. It is super titanium. So the entire case is titanium, and it's a mono block of titanium, which is just badass. It's a solid block of titanium. You see the back? You see the back, there's no screw down. There's no plate, right? Because it's a solid block. It's a solid block of titanium. It's eco-drive, it's solar powered, sapphire crystal, titanium, magnetic resistant, 200 meter water resistant, 20 bars, 200 meter, right? Japanese movement, has a date, solar powered. The titanium they're super titanium. It's 5 times stronger than steel at 40% lighter. It's quartz. It's not radio controlled, unfortunately. It's not radio controlled. They did make a radio controlled version that was Japanese radio only. So, but they did make one, but not in the US. But that's okay. I mean, it's still quartz. So it's accurate plus or minus 15 seconds a month, right? And so, when you adjust it, for daylight savings time, that's probably good enough, right? You change it if you change it twice a year change it twice a year, you're still accurate within a minute and, basically a minute and a half. And if you want to reset it more than that, you can. But basically it's a quartz watch. It's pretty accurate, man. Every quartz watch is more accurate than any mechanical watch ever made. This is the thing too. Like every quartz watch, a $5 quartz watch is more accurate than the most expensive mechanical you can possibly get. Because, I mean, it just is, right? Oh, and then the green is nice too. I really do like the green color. I have to say, I'm a huge fan of the green, as opposed to black. And green dials are also in right now, so that's nice. Green dials are also in. But here it is in my hand, so you can see it in person. It's just very clear, very legible. No muss, no fuss. It tells the time. That's what it does. It tells you the time and it tells you the date. That's what it does. So good stuff. So I like that watch very much, and it was a very nice gift. We got it for under $400. This says retail is $460. Nate negotiated it to under $400, I believe. So he got it for so I think like $390 or something. So from the jewelry store. So that was cool. We're still waiting for this thing to start. We can go look at some more watches if you guys like. Nate is a good friend. Nate is a very good friend of mine. Yes, we see each other like usually once a week in person. We talk on the phone a lot. Nate is a good guy. Nate and I are good friends, and I appreciate that he's a good friend because I need it in my life. To be quite honest, I need a good friend in my life. Yeah. So I think it's now my 10th watch in my collection, along with some other stuff. Oh, and then I saw this watch. And I don't know. Let me see if I can find this one real fast. Somewhere. Okay, here. This is it, I think. Yeah. All right, so there's this one. Which is interesting. Okay. See if I can get a better picture of this. Let's see if I can find a good picture. No, that's not it. Come on. Don't be mean to Uncivil. Give me a good picture. Okay. Now this'll do. All right, this'll do. So there's this one from a company I hadn't ever heard of really before, Bertucci. I'm not sure who Bertucci is, so I can't swear to their ability. But this one's interesting. This one's also a titanium. This is also solar and sapphire. And it has like these traditional, this is more like a traditional like military style field watch because it's got the 12 and 24-hour markings, which I kind of like. So I kind of like that. I've been looking for a watch sort of like in this style with sort of these markings. I got that Hamilton, which had that, but I didn't really like the black, and they don't make one in white for some reason. So I kind of like this watch, but I don't know, something about the casing or the implementation or something is just not hitting me the right way. And so I'm looking for like a watch like in this style with these markings, but I can't really find one I quite like. I had bought this one before I sent it back because I got it and I'm like, it's just not doing it for me. You know, I got it and I'm like, eh. And so I just sent it back. There's nothing wrong with it, incidentally. Something about it when I saw it in the real world didn't really work. So there's this one that I had gotten for like $500. You know, it says $695 here, but I got for like $530 from a store. So there's this Hamilton khaki field automatic. And see, it's like in that same exact style. And it's like, I should love it, right? I mean, it's nice and clean and good and all the rest of it. But I got it and I'm like, and it just didn't work for me. I don't know. Maybe it just wasn't hitting me right then. And I really wish they made this watch with a white face, but they don't. Not in the automatic. They don't make it with a white face. They do have a titanium for $1,200, but even then it doesn't have a white face. It's like blue. So I don't know what they're thinking there, but they don't have this in a white face, and it's odd. So yeah, I don't know. Got a Seiko Premier for 25 years, still working like day one. Been serviced once, capacitor dead after 18 years. Yeah, right? Exactly, right? Yeah, the capacitor will last, like 15 years. Yours lasted 18 years, exactly. So this watch doesn't need to be serviced for like 18 years. At which point, you could just get a new watch, incidentally, because like the watch was $400, right? So in 18 years, well, the cost per year was, what, $30 or something? So it's like, well, maybe it's time for a new watch instead of a service, but whatever. Yeah. Yeah, the band, it could be the band. It could be a lot of things. Obviously, with the band, you could replace it. You could get like a metal link bracelet. The band was not really working for me. That could be it too. I need to see it again at some point, maybe in the real world, and maybe I'll buy it at some point, but I had to send it back. Not for at least reasons, by the way. I just don't have the money. I don't really have $530 because I'm poor. This channel does not bring in the kind of revenue that Nate brings in. Just saying, we are barely keeping the lights on over here in Uncivil Law as it goes. So the old Omegas are cool. There's some cool vintage watches for sure. Yeah. Yeah, we did the Fed hearing this morning. We did the JM feed, but thank you. We did his feed of the hearing. If there's anyone else who has a feed of the hearing beyond JM Lawrence, if anyone else did a feed of it, I'd love to see what they had to say about it so we can get a different perspective. Yeah. So interesting. Seiko Spring Drive. I have very mixed feelings about Seiko Spring Drive. It's a technological achievement, but to some degree, why? Right? So for those of you who don't know what the Seiko Spring Drive is, it's very cool. And it's very cool mechanically, incidentally, because the second hand perfectly sweeps. Right? So it it's a perfect smoothness secondhand. It doesn't tick at all, right? Even most mechanical watches tick. They usually just tick at like 5 hertz or something. So if you watch like a Rolex or something, it ticks. It ticks. It like ticks. It ticks at like 5 hertz. So it does tick. It just ticks very fast, right? But the Grand Seiko, or some of them, and not all of them, incidentally, but some of them, the spring drive, they have a perfectly smooth secondhand, right? It doesn't tick. It just completely sweeps. So that's really cool. And the way they did that mechanically is also really cool. But fundamentally, at the baseline, it's a quartz. Fundamentally, at the baseline, the Seiko is a quartz. That's how they do it. They use the quartz to regulate the mechanical movement, right? And that's cool. But it's like, to some degree, why? And also, like, Seiko also had something very similar with the, what was it called? Mecha quartz. Where they do like that. It's different technologically. It's not one and the same, but it's a similar idea of combining mechanical and quartz components. So Seiko also has mecha quartz, where they did that, although I don't think they put it in as many watches, but they invented something very similar. No battery. That's true. Yeah. So it uses mechanical movement to charge the capacitor. Right. So that's interesting. So it doesn't use a battery. That's true. It uses mechanical movement to charge the capacitor to run the watch. So, I mean, it's very technologically cool. It's very technologically cool, no doubt. But, you know, I'm not saying I wouldn't buy one, although I'd want one that doesn't have a power reserve indicator, because again, it's like, why? Like, I don't really need a power reserve indicator, even if it's a 5-day watch. I don't need a power reserve indicator on my watch. Why do I need a power reserve indicator on my watch? I don't know. Right? I don't know. Either I'm wearing it or I'm not. And either way, it's like, okay, I'll just reset it. It's not that big a deal. I don't know. Or I'll just put it on a watch winder if I really need to for some reason. I just don't know why I need a power reserve indicator, but whatever. Slim Waste gives $5 to say, here's some money towards a bottle of vodka, Comrade Kurt. I appreciate the thought, but I'm basically not drinking anymore. It's not like a hard and fast rule. So it's not like I'm abstention, but I just don't want to drink. Right. And so like, it's hard for me to like remember the last time I had a drink. And that could be due to the Vyvanse or due to the Monjourno or due to anything. I don't really care, incidentally. Why would I care? It's like, it's just, I don't need to drink or I don't want to drink. And it's like, it saves me money anyway. And probably it's better for my health, all things considered. So like, I basically am not drinking anymore. So, you know, if we're out together and we're at a bar, I'll have a beer or something, you know, I'll have a beer or two, or even maybe 3 with you, but like, I'm just not like drinking on the regular. So it's not something I'm doing anymore. So that's cool. You know, I mean, you know, so yeah. It's not like there's a huge downside. I save money. It's better for my health, probably. It's good. Yeah. You know, when I was out at kickball, for example, just to like show you I'm not a total like fuddy-duddy, someone offered me a high noon, you know, beverage, and I had one. I actually had 2. So it's like, oh, it's not something I'm like hard and fast about. It's just like, I don't usually drink. So it's much more in control, I suppose. Yeah. Oh, and then I was also looking, and then also like in possible, you know, possible Dream Watch territory. There's also this watch. This is called the Hamilton Intramatic. It comes in different colors, but I think the Panda's pretty cool with that white and black dial. Date at the bottom. That's like a $2,000 watch. So that's a maybe someday, when I have money and I'm not trying to just buy food watch, but maybe someday. I really do like the two subdial look. I like that look. So that's pretty cool. White face with white hands. You're not sure you like that? I appreciate that. Yeah, I appreciate that. I kind of wish the hands were a different color too, now that you mention it. Yeah, I wish the hands were a different color so it was easier to read. Yeah, that seems like a mistake. I agree with your analysis. Now that you've pointed out, I can't unsee it. Oh well. Yeah. It's like you made the second hand a black. Why don't you just make the other hands black so the contrast is better, man? It's like, yeah, make it easier. Make it easier for me to read the watch. Ever been to Fortis? Not in particular. Oh, and then there's this watch, which is cool too. This one I actually do like a lot. This one is even more expensive, but this one's cool. So this one's like $2,500, but this is so cool. Hold on, let me see if I can get a good picture of it. You're making my life more challenging than it needs to be. Hold on. You gotta love it when websites make your life more challenging than they need to be. All right. There's this one, which is pretty cool. All right. So this is Sin. This is Sin. And this is called their Hydro U50. Now, this watch is really cool. This is an oil-filled watch. Now, that has a couple of advantages to it. First of all, oil being a liquid doesn't compress like air. So this is rated for 5,000 meters of water depth. 5,000 meters of water depth. So you can take it swimming. The second thing that's really interesting about it is because it's oil filled, you can look at this watch from any angle. You can look at it from any angle and you can read it from any angle. And it's legible from any angle because of the way the light hits the oil. So no matter what angle you're looking at, you can always see the watch. And it actually is really weird if you see it, because it's like it kind of looks fake because of the way the light because it looks like it's sitting above the glass because of the way it looks, because of the angle of light. It's actually really cool. So let me see if I can find a picture to show you what I'm talking about. Okay, I know there's a video where I can find it. Okay, hold on. Come on. Don't make me look bad, YouTube. Come on. YouTube is not being my friend right now. YouTube is making me sad. And I can't find a picture of it. That sucks. Take my word for it, though. It looks weird. Yeah. I can't find a photo of it right now. I hate it when I do that. I hate it when I start trying to find stuff and I can't find it. It always pisses me off. It's like, I just want to find it right now so I can show you. Okay, here's sort of a photo. It doesn't really quite work, but it's close as we're going to be able to get. All right, so like here is, so you can see the hydro watch, right? And then you see like the other watch, and you see how they're underwater. And you see how like that first watch, you can't really see it because of the angle of incident of light. You're looking at it from the side, so you can't really see it. So you just don't really see the dial. And then you see the SIN, and you can see the dial very, very clearly. So like that's kind of like what we're talking about, right? That's the effect. So that's a very cool watch. So that's in my list of potential watches in the future. Is this trial going to start, or is this hearing going to start at any time? Does anyone know when this hearing is supposed to occur? I've been killing time for a while now. Now, how much is it an awesome dive watch? Pretty awesome. Pretty awesome. I mean, with it being rated to 5,000 meters, unless you're diving, to more than 5,000 meters, yeah, the watch will be fine. You can dive to the Titanic and then keep going for a while. So if you want to dive to the Titanic, this is the watch for you.
I'm getting to that. I understand that. But if you'll allow me to make the argument, and you'll allow me to say what my declaration says, my declaration based on reasonable belief, this is how we get there. We would then ask the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration, there was no report, there was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember, no. That was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has...
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, but Ms. McLaughlin told us, We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again, that's news to me.
You were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time, in good faith. Both Mr. Unnetti and I asked the court to take evidence from Lieutenant Fanning. The court
I think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So, of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access, he didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you to a fair trial jeopardized. Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly. I take
So
the court
we
at its
will,
word.
we
But
will
the-
move on from that, Mr. Jackson. We'll move on from that, so.
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably. He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror. That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
All right, so that's your answer to my question.
That's my answer to
May I have a
the
moment
question.
to confer with counsel?
Yes.
I think the odds of Jackson getting thrown off the case are increasing with every moment, guys. I think they're increasing with every moment. Aunt Bev is not happy. Aunt Bev is angry Aunt Bev. I had my connection apparently dropped twice, by the way, for those of you asking what the buffering is due to, and I don't know why that's true, but I got 2 notifications from OBS saying that my connection had dropped and been reconnected. So sorry, don't know why, but apparently that happened. What can you do? It's internet. Lol. Pressing on.
Thank you for that. The court invoked Mr. Unetti and said, as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Unetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Unetti. So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
I'm happy to, Your Honor, and thank you for giving me the opportunity. The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Sallyport videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sallyport issue, or the Sallyport video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of D. Giampetro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious, so he's still around?
He is,
Okay.
yes, and he's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Canton PD is of critical importance, and that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built, and it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Sally Port interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sally Port. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sally Port interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D. Jim Petro retired, we received four videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment. These are four videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us. That's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sally Port video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. Exterior Sally Port. That means that the Massachusetts State Police not only had in their possession exterior Sally Port video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 25th. I'm sorry, January 2025, and they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination...
Can I just ask, was this of better quality than anything you had, or was it the same wobbly?
Same.
Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sally Port video? We now know that Buchnick watched some sort of exterior Sally Port video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024 because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sally Port video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute, on April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the Sally Port. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through
now
my
or no? If you can, if you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay.
It just, very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true, and we're still getting video evidence that is in their possession, custody, and control in October, in January? How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But in point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it? What page
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs.
Okay.
Crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. That's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote-unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton.
Yeah, I thought that was a pretty interesting argument too.
Exculpatory.
Yeah, how is it exculpatory? Yeah.
How is that exculpatory?
Yeah.
The condition of the taillight, that it was cracked and not shattered as it moved into the Sallyport. How do we struggle to describe that?
Yeah, I feel like that's kind of self-evident too. I'm with Jackson on that one.
Having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong.
Aunt Bev is now just secretly calculating in her head how long until she gets to go to lunch. All she's waiting for right now is for Jackson to stop talking so she can do something else she cares about.
Really weigh and balance.
She's probably playing Sudoku at the bench or something.
Battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sally Port. They finally took their medicine at some point and had to admit to the false time.
I mean, Jackson is talking. It would be really nice if there were a judge on the bench listening.
9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there. No, the defense is all wet. They're wrong. They just didn't account for daylight savings time. Oh, no, this was just a little mistake. It's not a big deal. It was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the Sally Port at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sally Port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it. It's their struggle to acknowledge it. Of course that's exculpatory. It directly...
The condition of the taillight when it arrived at that Sally Port is somewhat material.
One of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sally Port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally Port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. This is not a game of Wordle. This is not something that's supposed to be parsed.
Wordle.
All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved.
Right. How would the defense know what the Commonwealth has? How would they possibly know that?
Of all the Sally Port videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways. They write on page 4 of their opposition, quote, "The trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor," end quote. So they've taken the position, look, we personally did not know anything about that Sallyport video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts
Or the
State
United
Police
States.
and Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581, and this is Hornbook law, quote, "A prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation." And then Massachusetts Rule of Criminal Procedure 14A1A, "The prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case." Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence.
Or did so carelessly. Either way.
Let's talk about Michael Proctor's
They have the affirmative duty.
That grand jury. He was asked the following question: "Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked?" Answer: yes. Question: "Have you reviewed the footage of that garage?" Answer: "I saw one very grainy video, and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle." Question: "When did you watch the video from the Sallyport?" Answer: "I haven't reviewed it, sir, in quite some time."
So do you have those page numbers for me?
I can get them for you, Your Honor.
Okay.
I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
"I haven't reviewed it, sir, in quite some time, so I can't recall what's on there." Question: "Why did you review video of the Sallyport?" Answer: "We review every video we pull. We pull a lot of video. It's on the case officer to watch it." By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchanan. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact: by his statement, Michael Proctor admitted that, quote, "we pulled," end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C, is it Charlie?
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But You have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sally Port at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which
That's a
person?
pretty weird affidavit. That's true. I've never seen an affidavit signed by more than one person. That's weird as hell.
Odd, to say the least.
Yeah, that's weird as hell.
It certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry?
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time, and it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing.
Which you're not going to get that either.
Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton Police video system. We were not told that until well after trial. That was never disclosed to us, and I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The
Nice.
first time Louis Jutras was ever disclosed to
Always
as the
nice to use your
person who
opponent's
installed the
words when you
cameras
can.
at PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January.
Of course, the
29th,
judge has already
2022,
decided on
when the inverted
dismissal.
video was actually taken in
100%
July
we know that.
2024, because
Yeah,
it was
100% she's not going to
defective.
dismiss.
Interestingly,
No chance.
that's the only video that's clear.
But, you know, sometimes as a lawyer, you have to make the motion even though you know it's
That's
hopeless.
the camera that, according to the Commonwealth, was replaced as
As long as you're correct on the law, right? As long as it's a non-frivolous argument.
Its certificate of compliance.
Just because it's because you need to preserve it for the Court of Appeals or whatever. It's
42
like
minutes was missing from the Sallyport video that we
part of
did.
zealous advocacy.
Lo and behold,
You make arguments, you know you're going to get your teeth kicked in sometimes. What can you
that
do?
also purports to show the passenger side taillight, except as the court now knows, that's the one that was inverted. In the moving papers, in its
If I was a
opposition
judge, would I
papers, the
dismiss?
prosecution says, well, the prosecution had not previously received this video or knew of its
Probably not, to be
This
honest.
is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably 45 minutes, I would say.
All right, so we'll break.
All right, I guess we're breaking for lunch. That's exciting. Yeah. So, yeah. So he's making a good record. Yeah, the issue on the motion to dismiss at this point is basically that the harm has to be irremediable. That's the problem. They talk about prejudice. And what they really mean is irremediable. That's what they really mean. So basically, the state has to have done something that can't be fixed. That's the thing, right? The state has done something that can't be fixed. And if the remedy is like, okay, you can just have the evidence now, or, you know, you can ask these questions on cross-examination in the future, then that's the remedy, right? So if you were asking me as a judge, as a neutral judge, whether or not I'd grant this, probably not. Because it's like, okay, is there any other remedy I can give? It's like, well, you're raising a lot of questions about various things, but those questions could be raised as cross-examination questions with relevant witnesses. You're complaining about the fact that disclosures were not made timely. Okay, but you have them now, and you have sufficient time to prepare to use them. So from first principles, it's very difficult to find an irremediable harm that would require that kind of sanction. And as to whether or not, like, and then the only other thing that you could really go to is to say that this was willful by the government, which would go a long way towards reaching that factor. So the government has the duty to disclose in any event, right? That has no mens rea element to it. So the duty of the state to disclose exculpatory evidence is a duty that has no mens rea. They're required to do it. It's just part of what they're required to do. But in terms of the remedy for failure to do that, the willfulness of the state is an element that relates to that. And we saw that, for example, in the Baldwin trial. If you go watch back what the judge said in the Baldwin trial, she said that, right? She's like, first of all, there's no duty. First of all, it's a duty, plain fact. But the fact that this was willful, a willful violation by the government, now makes the sanction or remedy bigger, right? As opposed to non-willful or negligent mistake, right? And that makes sense, right? Typically, we punish people more when things are willful versus negligent. I mean, that's just, true as far as it goes, right? So we are in this position where, if I were the judge ruling this, I'd be asking myself, and as to willfulness, as to willfulness, that's somewhat difficult, I think, to necessarily conclude with respect to the issues that are presently presented. So I think on balance, I'd probably be disinclined to dismiss for these reasons. And incidentally, by the way, this is like what I'm talking about a lot on the channel. And they still don't have metadata. That gets into a different issue about whether or not they were entitled to metadata. And we could switch into that topic if you want, but that's a slightly different issue, right? So it's like you have to do this like every piece at a time. It's like, does the metadata exist, and were they provide what the state had? And also, to the extent that the Commonwealth and defense agreed on a process, then if that process was fulfilled, then we fulfilled the defendant's request, and that might be sufficient. So all those things. But this is one of the things that I think sometimes makes it a little bit difficult for me as a channel. And one of the reasons, for example, I think people perhaps don't like my channel as much as, for example, someone like Melanie Little, who I appreciate. Melanie Little is a great attorney, and I love her. She's a great person. But she I think is more like, I think she says more, this is just an outrage. And she just comes at it from that vein, which is not unreasonable. But I want to try to parse this a little bit more closely. And so it's like the precise question I'm being asked depends on the answer, right? And that's, we talk about that sometimes in law too. It's like the exact question matters as much as the answer, because the exact question drives the analysis. And so it makes it a little bit challenging sometimes, I think, for people who are free Karen Read, because they come to my channel and I'm like, well, I don't think Karen Read should be prosecuted. I don't think that. I don't think the evidence is really sufficient to convict. I don't think that. I think the judge really should seriously consider dismissing at the end of the state's case for failure to present a case beyond a reasonable doubt. I think that, right? I think that the case is shambles and a disaster fuel. I think that. I think the state's witnesses are jokes. I think that. But like, I don't necessarily think that the motion to dismiss now should be granted. I don't think that, the federal court should grant the habeas based on my best understanding of the relevant law, and so forth and so on, right? And so that, I think, makes it a challenge for the free Karen Read people, because I'm not necessarily rah, rah, rah all the time, right? And I think Melanie Little, for example, is more likely to be rah, rah, rah all the time. And, fair enough as far as it goes, that's her style. But, I want to try to analyze this more piecemeal. And I think that makes it challenging sometimes. I mentioned this before, and I mentioned this again. I remember when I was watching back my live stream with Melanie Little, because I like to watch back my streams and watch the chat and see what the comments are and see what people's feedback are. I remember one of the persons in the live stream basically said, Kurt, or Uncivil Law, either way, Kurt Uncivil Law has gone on record saying that he supports the Commonwealth in some of their motions. And I'm like, yes, that's true. Correct. You are correct. Yes, that is correct. Yes, I have from time to time said that I think the Commonwealth is right with respect to some particular argument or some particular issue that's in play. You are correct. I know you're saying this like a gotcha. I know you're saying this like, we got you now, right? You're not a pure. And I'm like, yeah, I guess I'm not a pure, I guess. I don't know what to do about that, though, in some sense. It's slightly annoying for me. I don't know what to do about that. And that also, incidentally, isn't to say that, by the way, I'm necessarily right. Of course, I'm not God, but I'm just going to try to analyze one piece of the issue. And if someone else analyzes it and comes out differently, then, I'd be interested to know why. And so maybe I can change my thinking or correct my thinking. I've been corrected before on stream, sometimes by chat, incidentally. Sometimes chat has corrected me, and I correct my thinking. Like it happened when we did Take Care of Maya, and we had that argument for like a half hour. And then after a half hour, you guys convinced me I was wrong. So it happens, right? It does happen. I'm open-minded, or I like to think I am. But what can you do? NDP 0911 says, for 999, I'm a retired detective, 23 years, and I cannot imagine a scenario in any court I've been in that I could take the same actions Proctor has and still get my cases prosecuted. I know, right? I know. This case is disaster fuel. The evidentiary issues are nightmare fuel. I mean, I feel like I feel like a group of high schoolers had at least an even chance of doing better than the Massachusetts State Police. Or at least they couldn't have done, or at least they wouldn't have done any worse. I feel like it's even money on the high schoolers, the untrained high schoolers, even money on them on them collecting the evidence in a better way than the Massachusetts State Police. It's like, I'm not a police officer, but I think I could have done better in a pinch. Damn, right? It's like, I'm not saying I know how to do your job better than you, except I totally am. Lol, right? It's like, I think I could have done better in a pinch, man. So yeah, I appreciate that. I don't understand like why the state wants to prosecute this case, given the state of the thing. It's such a disaster fuel with solo cups and lack of labeling and lack of evidence logs, evidence rolling around in someone's trunk for a month before we turn it over to the DA, and destroyed cell phones, and so many issues. There are so many problems in so many directions. It's hard to know where to start. It's hard to know where to start. So yeah. It's okay to root here, sure. It's absolutely okay to root for Karen Read. I think Karen Read cannot be proven guilty beyond a reasonable doubt. I don't think the evidence is there. I don't think she can be proven guilty beyond a reasonable doubt. It just doesn't make sense to me, right? And so it's like, that's the only question I have to solve, right? At sort of the end of the day, that's the question I have to solve. And again, it goes back to, what exactly is the question I'm being asked, right? What exactly is the question I'm being asked? And that's why it's important to keep your eye on the ball, right? In the context of Commonwealth versus Karen Read, the ultimate question is, can or did, as the case may be, the state prove its case as to each and every element beyond a reasonable doubt? That is really, in the end, the only question I have to answer. There are a lot of interesting questions along the way, as to what evidence should be included or not, or all the rest of it. But sort of the last question is, can or did the state prove its case beyond a reasonable doubt as to each and every element of the charge? That's it. That's the only question I really have to figure out, right? And I don't have to figure out whether or not Karen Rue is framed. I don't have to figure that out. That is not my job, right? I don't have to figure out who killed John O'Keefe. That is not my job. I don't have to figure out who killed John O'Keefe. Not my monkey, not my circus. I don't have to figure out whether or not she was framed. Not my monkey, not my circus. My question, as always, is, can or did the state prove each and every element of the charge beyond a reasonable doubt? Yes, guilty. No, not guilty. Super fun and exciting. Super fun and exciting. That's all I have to figure out. That's my job. It's the only question I have to figure out, right? I don't have, are you saying that you're letting her get away with murder? Are you willing to let Karen Read get away with murder? Well, I'm willing to apply the standard, which is, as I just said, right, beyond a reasonable doubt. So does that mean Karen Read gets away with murder? Maybe it does, but that's the standard, right? I'm not here to find the murderer. I'm not here to punish the murderer. That's not my job. I'm just trying to figure out whether the state proved it beyond a reasonable doubt. That's all I'm trying to figure out. Please stop asking me other questions, right? Please stop asking me other questions. That's the only question. I don't want to know anything else, right? Yeah, and then the Massachusetts standard also to a moral certainty, which I thought was already implied anyway, to be quite honest, but fair enough. I thought that was already implied in beyond a reasonable doubt, but fair enough. Yeah, also to a moral certainty. That too. Yeah. Innocent till proven guilty. That's the thing. Right. Innocent till proven guilty. That's the thing. Is she going to get away with murder? If the state can't prove its case beyond a reasonable doubt, you better bet your ass. That's what's supposed to happen. She's supposed to get away with murder if the state can't prove its case beyond a reasonable doubt. That is the correct answer. Right? What are we talking about? What are we talking about, right? So it's like, that's the end of the game. So that's the thing. Listening to the juror, I question the ability to do this. I question the ability of jurors to do this in the real world too. Right? We give them all the instruction in the world, but I think in reality, they're closer to a preponderance of the evidence than not in a jury room. I think that they are concerned with not letting the murderer get away with it. I think they're concerned with, a police officer is dead. Police officer being dead is not good. No one supports police officer being dead, right? No one supports police officer being dead. And I think in a not inconsequential way, this jury and many juries are concerned about letting the murderer get away with it because they don't like the police officer being dead. And so unless they can convince themselves she didn't do it, right? Unless they can convince themselves she didn't do it, they're gonna vote guilty because they don't want to let her get away with it. I mean, we try to give them all these instructions, but juror's gonna juror. What can you do? I suppose, right? Yeah, if you didn't do it, we wouldn't be here. Exactly. Right. This is why I've said, and I'll continue to say, there is a 5% base chance at minimum. It might be more than that. But there's at least a 5% base chance the jury's going to convict you just because you're sitting at the defendant's table. If not guilty, why guilty shaped? Yeah. Right. That's the thing. Yeah, that's the thing. And so it's like, what can you do? We try to give all the jurors all the instructions in the world. We try to tell them beyond a reasonable doubt. We even try to tell them moral certainty. And, then you listen to that juror interview. And, I haven't listened to the full juror interview. I tried to do a live stream of it once and it didn't really work. Maybe we'll try it again at some point and see if people want to watch. It didn't really work when I tried to do it. Maybe we'll give it another go sometime. But it's like, you listen to that juror interview and it's like, okay, do you think he understood the assignment? Do you think that juror understood the assignment based on what he said? It's like, nope. I'm just convinced beyond a reasonable doubt. I've done my due diligence and I just think, in my best assessment, that I'm convinced beyond a reasonable doubt. I just found the state's witnesses to be particularly credible, and I didn't find the defense witnesses to be particularly credible. And in my assessment, I just find beyond a reasonable doubt that's just my assessment. Is that what that juror is doing? Because doesn't sound like it. Doesn't sound like what that juror was doing. So he didn't understand the assignment. Yeah. And we try really hard to talk about beyond a reasonable doubt. We try really hard to write those instructions. And you would think beyond a reasonable doubt would be part of the zeitgeist. It's not exact. I mean, I know jurors are not professional jurors, but it's probably not the first time they've heard about beyond a reasonable doubt, one would hope. Right? It's probably not the first time they've ever heard this concept, one would hope. It's part of our culture and part of our zeitgeist. But still, they still don't understand the assignment. I don't know what to do about that. What do you do about that? And that's one of the reasons that some defense lawyers spend a lot of time talking about beyond a reasonable doubt during closing arguments. Because it's like, I have to hammer this through. And I'm not even sure even then it works. I'm not even sure then it works. So it's like, what can you do, man? What can you do? Maybe we digest the juror interview while we're doing lunches during trial. Not the worst idea, Tony, I've ever heard. We could do it in pieces. We could do the parts of the juror interview now while we're waiting. Do you want to do part of the juror interview now while we're waiting for lunch? We could do whatever it is, a half hour or 40 minutes of whatever it is, and lose our sanity. Does that sound like fun? Do you want to do this in pieces? Does that make the most sense? What do you think, Tony? Does that make sense to do it now, or do you think we should do it later? What makes more sense? Works for you? All right, we'll do it in pieces. That's fine. All right, let's watch this thing. Okay, Lord have mercy now. Let's watch this thing. I can't, just save me. Just save me. Save me, please. Reasonable and versus any doubt is vague. Yeah. Moral certainty, I would think, would have clarified that issue, but apparently not for some reason. You know? Massachusetts gives this moral certainty instruction, and even then.
See the justice system. I wish that it had worked out for everybody and there was closure all across the board, but
murder, that means
the entire group agreed upon. That being
doing
Okay, here
good,
we go.
thanks. How are you?
good. Thanks. Thank you for coming on. I appreciate this.
No worries.
Yes. So yeah, yeah, you were stuck behind a plow. I heard.
Do the
on
one
your-
he gave to Boston News. He gave an interview to Boston News. You'd prefer? Okay, we can do that. Okay. Karen Reed, juror interview, Boston News. All right. Let's, yeah, well, what?
We know this case.
This is only 3 minutes. This is a 3-minute video. All right, we can watch this one for 3 minutes. This will be fun.
We know this case has caught the attention of people from New England and beyond. And tonight we are hearing from a juror from Reed's first trial.
And we should note that this is the first on-camera TV interview that any member of the jury has done. And he spoke with our Eli Rosenberg in a story that you will only see again right here on NBC 10 Boston.
Kind of overwhelming at first, and then it got very interesting, and then at the end, kind of disappointing.
You had this front row seat. What do people not understand?
It's difficult for some of the public to understand why we arrived somehow to our conclusion, but it was totally based on the evidence that was provided to us and that we could actually consider.
At the time, there were
Okay.
a couple things during the trial that were a huge deal as it happened on the outside. And I'm wondering, did it resonate with you? One being the testimony of Michael Proctor, the lead investigator, and those texts.
It was very surprising. It was very unprofessional. And at that point, most likely we would discredit or not consider his testimony as strong.
Another big thing was this Google search. How's long to die in the cold?
We didn't believe that there was enough evidence or expertise to kind of indicate that it was reliable. It did not appear, at least to myself, that she intended to commit murder. The other piece, which was the leaving a scene of an accident, also did not appear very clear, and therefore everybody voted for those two charges as not guilty. That second charge, that was the one that was very debated in terms of whether ultimately she did it became questionable. And now that is where there was reasonable doubt in some minds. Unfortunately, we didn't get clarification early on that we could look at each charge individually and independently of each other. If we had done that, then I don't know where we would be or if we would be talking today.
Do you think there was going to ever be resolution on that second charge?
I honestly believe that there would not have been any resolution because some people had very good arguments, and at that point it was...
I'd love to hear them. I'd love to hear these very good arguments. Incidentally, I'm open to changing my mind. I have some doubts, but you know what? Okay.
Just trying to convince people and change people's beliefs, which would not be possible.
And this was interesting as well. After spending so much...
Okay, that was exciting for that 3-minute interview. Back to Turtle Boy.
Lucky Locker.
Yeah.
Second charge was vehicular manslaughter leading to death, basically. Yeah, vehicular manslaughter leading to death. Essentially, I could look it up exactly, but essentially that was it. So she needs to have hit him, obviously, right? And then there was some,
Yeah, of course.
It wasn't Lucky Locker, was it?
Yeah, I mean,
Oh.
the snow, right? We're trying to
Yeah.
beat the system, right?
Well, let me start off with that, right? There's actually an interesting video that I just saw come out that somebody took driving by 34 Fairview Road, and I want to have you visited 34 Fairview Road, obviously on like the first week of the trial, right?
That's correct.
What were your thoughts when you saw 34 Fairview Road and the car parked outside, you know, in the lawn? What did you think of the whole scene there?
It was surreal. I think it was very interesting to be able to see the atmosphere. It would have been nicer to see it in a little bit more with some snow, just to see what would that look like. But we were trying to observe the area and the environment at the time.
Well, funny you should mention that. So this is people love to do this. This is what somebody just drove by like an hour or two ago, 34 Fairview Road. And this is the perspective that 7 or 8 of the witnesses would have seen. And then John's body, of course, was later found right about here. Okay. And let me just ask you something right now, right? So they want us, the prosecution contends and the prosecution witnesses contend. I believe it was Matthew McCabe, Jennifer McCabe, Julie Nagel, Sarah Levinson, Brian Higgins, and 2 other, Caitlin Albert and Tristan Morris. They all drove directly by this spot while it was snowing at like between 1 and 2 in the morning. Every single one of them says that they didn't see a body on the front lawn right there. If you had seen this visual during the trial, would that have made it harder to believe that they could, if a body was there, that they wouldn't have seen it?
Yeah, I mean, it was very interesting because there were no pictures of what the body looked like at the time, right? So nobody took pictures of before they moved the body or moved the patient.
Yeah, that seems like an oversight. Maybe you should have taken some pictures of the body before you moved it. That might have been good.
It's kind of hard to believe you can't see anything, but again, it's hard to say that you couldn't see it, and it's also hard to say that you could. I mean, it's all speculation in that respect, but it'd be hard, somebody who's that large, to not be able to see something there.
Right. So when we talked before, you said that you were one of 2 jurors who wanted to ask the Judge Cannoni, about whether or not you were, first of all, do you confirm that it was a 12-0 vote for acquittal on murder and leaving the scene of an accident?
That is correct. So that was what the entire group agreed upon. That being said, it was confusing because we didn't have very clear direction on if it was all or nothing. In other words, if all 3 convictions had to be 100%. So that's why the response that it was that we were continued to need to deliberate because it was not clear on that one charge. So the one charge that we were not very clear on and not everybody was in agreement with was essentially the manslaughter charge, involuntary manslaughter. So that was the one that we were not clear on. But the other 2 charges, which was essentially second-degree murder as well as leaving a scene of an accident, was very clear. We all 12 agreed that was not the case. Right. So
right. And when did you guys start voting? So the first day you guys went and deliberated, it was closing arguments, right? And then you had like half a day there to deliberate. And then you came back, I don't know what day of the week it was, but you came back the next day, you had a full day of deliberations. When is the first time you guys took like a tally? And like when you said, okay, did you guys start with that? And did you say like, you know, let's see where we stand right now? Or how'd that work?
I think we wanted to read, essentially the first day, we kind of took it all in. And after that, then we started to do a vote. We clearly didn't have a timeline, or I can't recall exactly the exact timeline on when we first decided on some of those essentially convictions. However, it was very clear that each time we made a vote, we wanted to make sure that we read the charges. So
Okay.
very clearly read the charges and understand the charges each time.
So to believe that Karen Reed was not guilty of murder, that means that none of you, even if they thought that she did it for some reason, not a single person on that jury thought that she did it on purpose, correct?
That is correct.
Okay, so the whole motivation with about the Aruba trip with the Sullivan girls, and she's all angry. So that didn't really play well with you guys. That wasn't convincing.
It wasn't convincing. No.
Okay.
And there wasn't enough evidence for one way versus the other, but clearly not enough evidence, or there was doubtful evidence. So
okay. So you guys were hung on that second charge, and I believe the count, correct me if I'm wrong, was 6-6, right, for a bit, and you were one of the 6 for not guilty on manslaughter initially, correct?
Correct.
And then came the Tui Rodriguez charge, and that's kind of like a, come on, guys, you gotta give it your best shot, get back in there, and then that's when things. What was the atmosphere like in there? Was there bully sessions going on? Was there people trying to urge people that, come on, we got to do this for the O'Keefe family. They deserve some sort of justice. We got to do something. What was it like in there?
It was deliberation. So clearly, one of the things that were happening is we were trying to examine all the evidence and looking into holes for the case, whether on one side versus the other. And ultimately, that's what led to some people swaying in one direction, and then some people remaining and standing their ground. Some people essentially remained and stood their ground the entire time. And I think that was, I think it's important to see that in terms of the justice system and having this 12-panel jury. I think it would have been one way or the other if it was left to a very small group or only a few individuals. But given the circumstances that it was left to 12 individuals that have to ultimately come up with the same decision, I think is a very good system as it is.
So it's a couple people changed their mind though. So there must have been some leaders in that room. Have you ever seen the movie 12 Angry Men?
Yes.
It's a classic. So obviously in that movie, Henry Fonda is very convincing. He has a strong personality and he's able to sway 11 angry men to come to his side. So surely like the vote was 6-6 and then it went 9-3 for guilty. So I'm guessing there must have been some dominant personalities in that room. And who would you say that? Would you say the foreman was one of those, and an engineer? Is that correct?
I think a lot of people were strong in that room, in that they were opinionated, and based on their opinions and their level of expertise and what we were given in terms of evidence, that's how we ultimately arrived at that conclusion, or each individial arrived at that.
Okay, I was going to say, you guys didn't come to a conclusion because you hung.
Correct.
And so it was 9-3, and you kind of wavered a little bit, right? Like they convinced you one way, and then like what you told me last time was it was 9-3, and you were kind of on the fence, and then you kind of came back, and there was 8-4. Is that an accurate depiction of what happened? Would you say it ended in 8-4 for guilty to not guilty?
That's correct.
Okay, and you, correct me if I'm wrong, you told me that you and one other juror wanted to ask the judge, Judge Cannoni, whether or not you were allowed to acquit on two of the charges and hang on the third, and that the foreman said, no, we're not going to do that. We have to decide on, it's all or nothing.
So it was not a question of whether we can acquit. It was a question on, can we make decisions on each individual conviction independently
Each
of
individual
each other
charge.
versus,
Yeah.
so that was the question. It wasn't
Right, yes.
necessarily.
Right. So acquittal, conviction. Yeah. So like but you wanted to ask the judge, are we allowed to come to a decision on 2 of the charges and hang on the 3rd? And the foreman said that's not going to happen. No.
And it wasn't necessarily just the Furman, but there was a bunch of other opinionated individuals also kind of saying that, no, I think we have to look at it as a whole as opposed to independent. But clearly the person who was in charge at the time was the foreman. So his word or their word was more pronounced.
So those notes that he would write, were those group efforts, those notes, or like, I mean, they were well written. Obviously, a lot of people have talked about those notes, and the SJC in particular looked at those notes, and he used the word charges plural, and that was a big. The SJC cited that a bunch of times. He said that we are deeply divided on the charges. He said, and did you guys come up with that note together, or did he write that himself, or did ChatGPT write it? How did that get written?
It was written by the foreman with, in collaboration with all the other jurors. So
Okay.
we all looked at it. We all kind of accepted it as such. Again, it was one of the questions that we wanted to ask the judge was for clarification on can we look at these charges individually? But ultimately, that kind of question was put down, and essentially we had no choice but to just, again, based on the group, right, or majority rule, to say that we were just going to ask one question, or it's an all or nothing scenario, as opposed to can be treated individually from each other or independently from each other.
A lot of people would say that if they were in that situation and they were not being allowed to talk to the judge, they would say, well, too bad, they would make a bigger stink about it. How did you feel about that? Do you feel like after this happened, do you feel badly for Karen Reed that, that she was acquitted, you were in that room, you guys all voted a bunch of times, and if you had just known, if it had been communicated to you better, if you're not, the whole thing was just seemed like you're not professional jurors. That's the way one of the jurors put it, is like, I'm not a professional juror. It's my first time doing a murder trial. I don't know how this works, but I know we acquitted her, and this seems like a technicality. Do you think Karen Reed got the shaft?
Yeah, I think it's totally unfortunate because we just weren't well informed. And you're right, we're not professional jurors. We don't know how the law works. And it's kind of sad that, or unfortunate that we don't have that kind of view from an individual. So if we're in law, we would know how it's supposed to work. But from somebody who's new to becoming a juror or being a juror, we wouldn't know how the system really works. Mm-hmm. So it was very unfortunate circumstances.
Yeah. So just random question. I have so many questions, obviously, but one question is, you're obviously of Asian descent, and during the trial, there was one point where they were reading Matt McCabe's text messages out loud, and David Yannetti was cross-examining him, and he was reading them. And Matthew McCabe said something about like the Asian house. And I thought that was, I knew there was 2 Asian members of the jury. And I'm like, I wonder if they did that on purpose. Did that come across to you as at all offensive or anything like that? Him calling it the Asian house next door?
I think borderline kind of, I think it's borderline kind of offensive, but I don't think of it as offensive because I was born and raised here. So I think I looked at it as just somehow a descriptor, but I can see how some people would be offended by that kind of terminology.
Well, I think I think the defense was hoping you would be offended particularly by that. I think that's why they had him read it, is because he called it the Asian house. And I wasn't in the courtroom for that one because I wasn't allowed to be in there when Matt McCabe testified, but so I didn't get to see the reactions of the two Asian members of the jury.
Yeah.
So I wasn't sure if it landed or not, but you were there on obviously the closing day of closing arguments, and Brian Albert, Colin Albert, and Jennifer McCabe walked into court and sat with the O'Keefe family, and just the way they were positioned, they were staring directly at you. How did you feel about that?
It was a little intimidating. And I say intimidating, it was just at the end. I think we're all at that point where we want this to have some closure. And I think it was slightly intimidating to see everybody there and all the players there, to some respect. I wouldn't say so much that I was fearful, but intimidated by everybody staring at me, right? So, or looking at me, and I say me, but it really is the group,
14,
right? The jury.
Yeah, all 15 of you that were up there and sat through 3 months of this, and you didn't get paid. I mean, they didn't really pay you for this, like $50 a day or something you got?
Yeah, some small amount, yes.
So you gave up all this time, and God bless you, because it was hot sometimes in that courtroom, and it was a lot of the testimony was incredibly boring. I lived for this shit, and even I was bored by some of it. And I looked, and sometimes jurors were falling asleep because Adam Lally can just put you to sleep sometimes. How do you feel about the fact that you gave 3 months of your life to this, and ultimately the result was nothing?
I feel that we kind of failed the system in that we were charged with this responsibility and we came up with certain decisions, but at the end, it was not kind of looked at or taken into consideration in terms of some of the charges. And I think that was a failure of the system, and it is a disappointment. But that being said, I think it was a very good learning experience to be able to see the justice system. I wish that it had worked out for everybody and there was closure all across the board. But right now, there's no closure for the O'Keefe family and for the Reeds, right?
Yeah.
So there's nothing there.
So you are an EMT, which is such a unique job, it's particularly for this case. And at the scene, the EMTs were the kind of the first people to testify. And I think they interviewed like 8 or 9 of them. And 2 of them, no, I apologize, 3 of them testified that they heard Karen Reed say, I did it, I did it, I did it. If you came across a car accident or something like that with a dead body on the road, and there was a woman screaming, I did it, I did it, I did it, would you tell the police what she said, like then and there, and this woman's confessing to a crime?
I honestly would focus on taking care of the patient.
Fair.
And not necessarily focusing on that individual. That being said, if that individual was my patient, then obviously I would need to disclose that information to law enforcement. But at that time, if my patient was Mr. O'Keefe, then I would focus on Mr. O'Keefe and his resuscitation first and foremost.
Fair enough.
Focusing on John O'Keefe's resuscitation. Yeah. So when they got there, the ambulance got there. They were there for about a couple minutes trying to resuscitate him, and then they immediately put him on a gurney, put him into the ambulance, and got him out of there. And you must have come across fatalities many times, I'm guessing. Must. I mean, God bless you. I don't know how you guys do it, but I'm assuming You've seen too many dead bodies. When that happens, you've come across car accidents, I'm assuming, many times too?
Yes.
Okay. So what is the protocol? Like, what would the protocol in a situation like this be? Do you think that the police and the first responders handled this in a way that you would expect it to be handled? Like, not as far as not putting crime scene tape up or anything like that?
I don't think it was as coordinated as it should be. And I don't know if that's a fault of necessarily each individual or a problem with the system, in that maybe they didn't have the proper training, or they should have asked more resources to actually make sure that it was done well. But I have to admit, it does not seem like it was done well in any way, shape, or form.
So, are you qualified to look at, like, a person's body after they're deceased and determine cause of death? Is that something you're familiar with as an EMT, or is that not something you're trained to do?
That's not my forte. I'm not necessarily, all I know is based on what is provided to me in terms of evidence, but I'm not in any way, shape, or form a educated person on pathology.
Well, luckily, there were 2 experts provided by the federal government from a company called ARCA that testified, 2 doctors, and they were the last 2 witnesses to go. And in order to, they both testified that, according to the physics, the science and the physics, the injuries to John O'Keefe are not consistent with being hit by a car, and the damage to the vehicle is not consistent with hitting a pedestrian. And so those guys are, doctors, PhDs, they do this for a living, etc. And in order to find Karen Read guilty of manslaughter, you have to listen to the ARCA experts and say, I don't believe them. So how did 8 jurors reach the conclusion that those guys didn't know what they were talking about?
It was as a direct result of Karen was there at that time, and John was there at the time, and it was believed that John died there, therefore, right, at that location, and therefore it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house, and as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or somehow, some sort of involvement by Miss Reed. So that was how they all arrived at.
But how did they?
Yeah, but the ARCA experts said it defied the laws of physics. We're going on the fact that John O'Keefe was there and Karen Read was there, therefore Karen Read did it. Okay. Nah, right.
Reconciled, was the ARCA testimony brought up by the people that thought that she was not guilty? Did they? I'm sure somebody in that room must have said, but these experts are telling us that that's not possible. And what was the answer to that? Like, did people say that that these guys are bullshit artists, that they're fake doctors? Like, what was the reason not to believe them?
I think the major rebuttal was, we don't know. And that was the other thing. It was very ambiguous on why these individuals were testifying. And so there was a question in the group on their essential integrity, in terms of, were they there as a direct result of somebody else trying to steer us in a different direction and confuse the jury. So it wasn't sure if it was insurance. It wasn't sure if it was, whether the Reeds were doing it, somebody else was doing it, or yourself was doing it to bring this group to try to testify so that it would sway the jury in one direction or the other. And that, I think that was one of the things that was, again, unfortunate, because I guess it cannot be said, or didn't want to be revealed to us on what were the circumstances of why those individuals were testifying, other than they were testifying for the defense. Because
now, obviously, now that the trial's over, that they weren't they're not even defense experts, they're FBI. They were available to both sides, and only the defense called them. But it seems like the conversation in the room went, and they said some people were suggesting maybe they were the insurance company, of course, because of course an insurance company would benefit from not having an automobile collision. Obviously, they wouldn't have to pay.
I couldn't swear to it, but I would think it would be somewhat unlikely for an insurance person to testify in a criminal trial. You know, that doesn't really make sense. Why would the insurance company send someone to testify in a criminal trial? They would send someone to testify in a civil liability trial because they're concerned about their civil liability. That doesn't really make sense. Why would it be an insurance company? Yeah.
Anything out, or me? How did people thought I paid the ARCA guys? That's wild.
Like anybody, somebody was trying to, again, to try to sway the jury in one direction versus the other.
I'm not that powerful, I promise you. I can't afford those guys. But so that's basically the reason that they came up with. They said they heard all their testimony, and then they said, nah, those guys are just probably paid off by the insurance company. We're going to disregard everything that they said.
People online were saying insurance guys would testify she didn't do it to keep insurance company from having to pay for his death. Yeah, see, that doesn't make sense. Because they would testify in the wrongful death trial for civil liability, not in the criminal trial. Because they're concerned about their civil liability. They testify in the wrongful death trial, not the homicide trial. That doesn't make sense. I don't buy that.
And one of the other reasons is because there was the other testimony of the individual from the dog bite expert and all of the other things that the defense was trying to bring up, that again, wasn't sure if it was just to try to confuse or sway the jury in one direction versus the other, or create a
I just would like to can we just put all that aside for the moment? If you want to ignore every defense witness, that's fine by me for the moment, because the state, of course, has the burden of proof. Can you just tell me, like, I guess it was because they were at the same center in the same time, and we didn't think that he had went inside, and there was some damage to the taillight at some point. Therefore, she's guilty. I guess that's the answer. Okay. All right. I guess. All right. That makes. All right. I suppose that makes sense in somebody's head. I suppose that makes sense in somebody's head.
Jury, which was created reasonable doubt, and therefore the vote had to be in one direction versus the other.
The defense doesn't have to create reasonable doubt. That's a mistake. The defense does not have to create reasonable doubt. The defense has no obligation, zero. The defense doesn't have to do anything. They don't have to do anything. They don't have to say one word the entire trial. The defense has no obligation. Okay? So, all right.
So it sounds like what you're saying is that some of the jurors in the room were saying that all of this defense third-party culprit thing, a dog biting John, this is all bullshit. This is all a smokescreen, and all these people, this dog bite expert they're bringing in, this is all a distraction from the fact that Karen Reed ran John over. Is that an accurate portrayal of what people were saying in that room?
That is correct.
Wow. Okay. So in order to believe that Karen Reed killed John O'Keefe, you have to believe that, and that John O'Keefe didn't go inside the house. You have to believe all of the McAlberts who testified. And so am I correct in saying that they found the McAlberts to be convincing witnesses and truth tellers?
Correct. And I will say that that's to some respect, not not only to say it's correct, but also to some respect, because there were some individuals who just looked at the facts. Again, the clear fact
That would be a good thing to do.
Karen was operating a vehicle and
She was.
Drove the vehicle to that location.
She did.
34 Fairview.
Mm-hmm.
And then ultimately John O'Keefe lay at rest and died.
Okay, we're missing some steps along the way, guys. We're missing some steps. Karen Reed drove to the scene. You're right. She drove there. You got it. John O'Keefe's body was found. Therefore, Karen Reed is guilty. We need some steps in between here, guys. We need some steps in between here. Okay, that's fine. I'm fine. I mean, not to put too fine a point on it, but that also applies to the tow truck driver, right? The tow truck driver also drove to the scene, right? And then John O'Keefe's body was found. Maybe it was the tow truck driver. How about that? That works for the tow truck driver too.
On essentially that address. And so everybody else is saying that he never entered the premises. Therefore, she must be at fault because he clearly did not just injure himself there. So
Did any?
Well, I mean, maybe someone else was outside the house.
Anybody suggest that maybe the McAlberts are not being truthful? That maybe he did go inside? I assume somebody in the room, the not guilty voters, must have said that these people are lying, obviously. And what did people say to that? I mean, did some people believe at least that they weren't being honest?
I think the individuals who believe that she was not guilty was because of the mere fact that it was not adding up. So the injuries to John O'Keefe ultimately did not add up to the damage to the vehicle. Mm-hmm. And what ultimately injured him was, or led to his death, was a injury to his head, which was not very clear that type of damage could have occurred on the vehicle, and there was no damages on the vehicle that would indicate that kind of situation. So for those who are skeptical, that's...
Wow, that sounds like the people voting for not guilty sound a lot more reasoned to me. That sounds a lot more reasoned to me than Karen Reed was there, John O'Keefe was there, therefore Karen Reed did it. That chain of logic, I have to say, does appeal a lot more to my heart. Yeah, that sounds better to my mind.
What they were looking at.
Yeah, the Commonwealth alleges that that his arm, I still can't believe they said this theory, that the arm was out and that the arm is what caused the taillight basically acted as a knife and just sliced his arm up and then caused him to spin and
pirouette.
Then 30 feet
pirouette.
on the grass. And the gash in the back of the head came from hitting the grass, which they said was so hard that it somehow caused a gash in the back of his head. People really believe that?
Yeah, I mean, I don't think a lot of people in the room, some people who were experts in science, right, and physics, or have some knowledge of physics, necessarily believe that as the case, given the circumstances, that it was not very clear. Mm-hmm. But again, some individuals just believed at the circumstance that Karen and John were there at the same time, and John ultimately was killed.
And the texture.
I don't know what to do with this. Karen was there. John O'Keefe is there. John O'Keefe died. Therefore, Karen Reed did it. Help me. Help me.
Stream data is what you mentioned to me a lot last time, and you said that was what the guilty people really stuck to was the text stream data. What was so convincing about the text stream data for them?
It was a combination of the speed, and suddenly there's an increase in speed and a decrease in speed.
I was, more willing to accept we didn't believe the ARCA experts. I mean, I get that at least somewhat. I mean, the credibility of the witness is obviously a matter for the jury. And so I suppose a jury could say that the ARCA experts weren't particularly credible. I'm not sure how, but, like in theory, I guess that makes more sense. But I'm still back to like how the state prove it, right? It's like because the state's burned, right? So if you want to disbelieve the ARCA experts, I'm like, okay, that's fine. We can disbelieve the ARCA experts if you like. That's fine. How are you getting to proof beyond a reasonable doubt again? Well, Karen Reed was there. John O'Keefe was there. He died. Therefore, okay, no, just no. Just no. Just none of those things. None of those things. Absolutely not. None of those things in any way.
Consistent with maybe somebody backing up. And so that looking at that was kind of convincing that she must have accelerated in a backwards motion. And then
even though that 24 miles an hour in reverse 62 feet thing, there was no time associated with that. It was measured in what's called key cycles, and they couldn't explain, like, at least they didn't say for sure, like, this happened at 12:32. For all we know, that event could have happened at another time or another place, because they didn't give us a time. But people were pretty convinced just based on that alone that, yeah, that's proof positive that it happened at that exact same time.
I think it was a combination of, again, the circumstance that both individuals were there. There's evidence of a broken tail light, the injury to John, and the injuries that John sustained, and then ultimately that texting data was just another piece that indicated, yes, there must have been some movement. It was very interesting, though it wasn't very clear, and I think I said this last time, that it would have been nice to have somebody who is an expert in that, or somebody who has knowledge of that type of data from that company, right? From Lexus or whatever company, right? And to provide some information on if that can be accurate and what causes it to actually occur. So, for example, like I was saying, or I was thinking, like right now, as I'm driving home, right, my car could have slipped, and that could have triggered something, right, to suggest that maybe that will make a trigger that I'm driving kind of erratically, but it's not because of me, it's because of the ice and the snow on the roadway causing that to occur, which we all know that during this time frame, that's the type of weather that was being experienced by.
We did establish it was snowing.
Karen,
That's yes. We established it was snowing. Yeah.
So if the defense had an expert from Toyota or whatever that could explain, like, is there anything that could make it look like you went a certain velocity and you really didn't? Maybe your tires were spinning, maybe the RPMs were up. That would have been a good witness for them to call.
I think that would have been helpful. That was definitely would be a helpful piece.
Okay.
But like, even then, it doesn't really matter. It still doesn't matter. And even like Turtle Boy is basically trying to feed him like the answer that would make sense. Turtle Boy is trying to feed him the answer that would make sense. It's like, oh, were you able to, using key cycles, like obviously it's not linked to time because the car doesn't know what time it is, right? But the car knows when various things happen in sequence. It's like, okay, so were you able to like satisfy yourself that this event occurred at this time based on that key cycle data? Were you able to like satisfy yourself that happened at the same time? And he's just like, well, no, it was just based on the fact they were together, right? I mean, at least that answer would make more sense, right? That answer would make more sense. It's like, oh yeah, no, I was able to, in my own mind, link the key cycle data together. And I was able to, using some key cycle data and a little thought, I was able to say, oh, this must have occurred at this time, and that's when the murder occurred. So that would be stronger evidence implicating Karen Reed, right? If she was going back 25 miles an hour, at the time when the death occurred, that'd be much better evidence that she did it, right? It's like, okay, that makes sense. But he didn't say that. He didn't say the jurors are like, oh, they were able to link the key cycle data. He's just like, well, the car at some point, we're not sure when exactly, but the car at some point was going back 25 miles an hour. We don't know when, and we weren't able to link it to the time, but Karen Reed was there. Okay.
Let's talk about reasonable doubt. Going back and listening to it all, the defense gave you this story about what they think happened, how John O'Keefe went in the house, he was beaten up, and he was left outside to die on the lawn, and then Karen Reed was framed there after the fact. All right. And what I didn't hear much from the defense in their closing arguments was about what reasonable doubt was. Did you guys discuss what reasonable doubt was in the jury room? Was that made clear what that was? Because some of the things that you're saying right now is reasonable doubt. Even the arguments that Karen Reed, from the people that believe Karen Reed is guilty, they're making arguments for reasonable doubt. Did you?
Yeah, it kind of sounds like it to me, right? Kind of sounds like it to me. It kind of sounds like reasonable doubt. It's doubt based on reason. It's like, I have doubt. I'm not sure. And here's a reason why. That's. You
guys understand what reasonable doubt was?
I believe we did, and that's where we kind of essentially got stuck, is because I think that's why it ended up as a hung jury, is because we kept rehashing that second.
Well, that was exciting and fun.
Jackson, go ahead and continue.
Thank you, Your Honor. When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally, perhaps it wasn't Ms. McLaughlin.
There we go. There's some video.
Was it Chief Rafferty?
There you go.
Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them. And that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchanan with it. They indicate they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth, during this debacle, had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchanan under direct examination by Mr. Lally. Going into the next day, still under direct examination by Mr. Lally, they played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was in fact Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least, in its initial comments to me was, you may have said something that you don't have a factual foundation for. And I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit...
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. He's on the other side of the car. That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of a camera, and then when the Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
And
was
you
untrue.
cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutors sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence: the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation?
That's a fair question,
with the
man.
sentence
That is a
the
fair
prosecutor
question.
Was unaware. It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now, through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have, on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth in a report from Sergeant DGM Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th, so it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, "I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station," end quote. He goes on to say, quote, "Due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting." This is the first we're hearing of any of this last Thursday. How is that? Sure. Ms. Lewin just handed me a clean copy of the DG and Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes.
You probably did.
So I've seen it.
Okay. May I approach Representative?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if that's
Sure.
all right, Your Honor.
Sure. I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
No, thank you.
So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
Exhibit 1 so marked.
Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DG and Petro, he downloaded every single bit of video of that car while in the Sallyport or while at Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DG and Petro, quote, it says, quote, "I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense." The "you and I" is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out, for the first time, that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG and Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that "you and I believed may be needed to refute claims made by the defense." They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over. probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night.
Yeah.
There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that.
I really wish it was the legal definition of bad faith and intentional.
Trial and then after,
But
we received the inverted
no,
video.
not necessarily. I really wish it was though, but
As the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchnick's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022. He knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2. In July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added Canton PD 12922 and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little differently.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony, so it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. Exterior Sally Port. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sally Port, which was grainy and had a camera vantage point from the front of the Sally Port. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sally Port camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
Okay.
Are there two so marked?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
You have an extra copy? Is that one clean?
Not clean, but.
No, that was the only copy that I've got.
May I approach, Your Honor?
Please.
This one has highlights on it. I apologize.
It's okay. Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sally Port videos? Who does he say was requesting the Sally Port videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason it could have been Trooper Proctor. Seems to be reasonable. But I don't know because Trooper Buchanan doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing.
I know what she would say. She'd say you can ask that question on cross during trial.
Michael Proctor was receiving the footage directly from DG and Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with, because we didn't have any of the evidence that had been secured concerning that Sally Port. Question. There's surveillance video from Canton Police Department's Sally Port garage that wasn't turned over, right? Answer. That video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
She asks like she cares.
Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing she
I'll provide that to you
can.
in just a moment, Your Honor.
June 10th?
It was either June 10th or June 12th, but let me double check.
Well, she's looking for that, Your Honor. May I
Please go
proceed?
ahead, yep.
Okay. The only thing it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing, and a flatbed and the flatbed driveway footage outside the Sally Port that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it, and he received it, according to Sergeant D.G. Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this.
But now you can. See, that's the problem.
He made sure that
Now
all
you
the
can
footage
impeach him
was
with it.
delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible, with all this sort of years-long flurry that we've just talked about surrounding these Sally Port videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is.
There you
I'll
go.
give the prosecutors the benefit of the doubt.
There you go, right?
Is it reasonable? That's another question. To believe that they just knew nothing about this. We know
Yep.
Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter.
It does matter as it relates to good faith or not.
The prosecution,
Of the prosecution, it does matter.
Michael Proctor. And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Sally Port garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sally Port. The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors have never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth. In quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went, and why we don't have them, and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated.
Yeah, that's a little bit hard to get to when it was the government's fault.
Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights.
I have to say, I'm not really a fan of citing the dictionary in almost any circumstance.
When they're the ones doing the
Find a different way. Please don't do Merriam-Webster's defines. I just find it unbelievably painfully cliche.
The forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith, and this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument, but the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this, it just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know, through this new revelation, that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven, and thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards.
It's probably a pretty good place to go.
Conduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and finds that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial.
But you can now. You can now. That's the answer.
Were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over
What word was it that was defined by Merriam Dictionary in this hearing? What word was it? Was it prejudice? Or was it aggrieved?
And prejudice is that
what was the word he defined? Does anyone remember?
In our moving
We're
papers.
going to look it up.
And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself,
Aggrieved?
there's no question
Was it egregious?
that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5
Aggrieved? All right, let's look it up.
different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over.
No, aggrieved does not have a definition in the Urban Dictionary.
And the Commonwealth then compounded those
Oh, I
violations
misspelled it though. Well, that's probably why.
by Michael Proctor lying on the stand
Oh, no, there we
about
go.
his knowledge of the video footage and his turning it over to the defense. It was literally a fraud.
Feeling resentment of having been unfairly treated. Quasi-feminist male domination, demonization rhetoric.
Well, after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence.
I don't see how anyone other than me has been aggrieved when it comes to AI. Sounds like a bunch of effing parasites trying to dug their fingers in something they actually aren't part of. Okay, that was insightful.
Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled?
Even then, the remedy is almost invariably a new trial.
Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth. And
What does Urban Dictionary say for the word fun?
This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though. And it's the cumulative effect of all these gross
Fire that burns the whole town.
that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously...
Cody and David activities. I don't know what that means.
Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence.
I asked Candace to come over to my place for a fun time. When she left, she said, I love tea and crumpets. I can't wait to see you again.
The exclusionary rule exists.
I understand that that does not help the defense.
It doesn't help the defense. And I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, If the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual...
You can have an evidentiary hearing. It's called the trial.
...issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the Proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just for the court's reference, lines 8 through 12.
Great.
Thank you.
All right, I have a question, Mr. Jackson, just about, so you argued, obviously, the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked, rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No.
As Dighton Police, Barrows testified. All right, where do I find that 47 pieces?
The 47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial, that there were that many pieces found at the crime scene.
It's the number of pieces that were booked into evidence.
Okay.
Yeah.
Eventually.
Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it. Because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight recovered at the
That's not clear to me the way this is written, so I'm glad I asked you. Okay.
Really?
All right, so with that, now, Ms. Tina,
Are you really confused? Or are you just trying to be
in
confused?
charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense, so I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sallyport videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial. At that point, there had been no request by the defense for video of the Sallyport area. What I learned is that Trooper Proctor had requested Sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police Video, who would download it from the DVR, was Sergeant D. Giampetro. He made a request shortly after this event on January 29, 2022. Sergeant D. Giampetro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D. Giampetro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Sallyport and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D. Giampetro.
Even though we already had it?
For different cameras. He wanted cameras, camera angle of outside the Sallyport area, so when the tow truck dropped the car off, leading into the Sallyport, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified, or was asked about video, and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, Atty. Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. Atty. Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022. I'm sorry, it was provided April 4th, 2022.
2022 or later?
No.
It was later, right?
It was
Because
later.
the federal grand jury was later.
He provided it on the eve of trial, so it was April 4th, 2024. So we know this production on April 4th, 2024 was in the hands of Trooper Proctor shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior Sallyport. As trial began, there still was no specific order or request. The chief of police provided, who was saw something about the trial and, let me rephrase, prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera salad port was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yannetti's concerns, then asked Sergeant D. Giampetro to see if there was another camera or to produce any other video from the sally port. Sergeant D. Giampetro then downloaded video from the DVR, which is the second camera that is inside the sally port, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior sally port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the sally port and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives, and because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial, and it is noted in the sergeant's letter. The chief of police and the sergeant were downloading video not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I've said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station, I learned about the videos, and then as a consequence, I spoke to the chief, other officers, and the sergeant. Unexpectedly, the sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything, so I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Buchanan to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Of course it was. Of course it was. All roads come back to Proctor. All roads come back to Proctor.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Okay. Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. They have produced absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose, and again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which is about 3 sentences, but if you actually read a number of pages of his testimony that deals with this video, and it begins on page 133, what you will see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton Police. And you can also see that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Sallyport video, and also there's an exterior video outside the Sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sallyport and there's the exterior video. So clearly Trooper Proctor was aware of the exterior Sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it, because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course. And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory.
No one was asking you to do that.
Relevant material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was an evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe.
Yep.
In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now that recently has changed. If we see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has. It's important to look at the motion that has been presented to Your Honor on behalf of the defense where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know that the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so, Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions. Very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for Your Honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75 But you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Greeno says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard-pressed now at this moment where they are trying to create prejudice that doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence, to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you see in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting, I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. Answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they ask you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So,
Do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't, perhaps Attorney
I'm sure Ms.
does.
McLaughlin can get it
I'll
from.
provide it momentarily.
All right, thank you.
Okay. So what really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information, is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros' testimony. And if you have an opportunity to look at his testimony, on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged, it was cracked. But they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on, after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barros, says more. And so if that taillight is not just cracked, if that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring.
No, wait, have we gone from a piece missing to the whole taillight being missing now? I'm confused.
A fractured taillight, if it's already gone before it gets to Canton, there can't be.
So by a piece missing, we meant the whole thing, basically? That's what he's going with?
Unequivocally
Okay.
clear. That piece of the taillight.
There was a crack,
is
but there was a
missing
piece
well
missing.
before that car ever gets
Including the whole taillight. So a crack in what? I don't know.
We can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the fact, the claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense, and I just want Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the Sallyport area. Now you can see, if you stop that please.
We're doing evidence review time now?
On that wall, on that garage wall, there's a 4. It is backwards. This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that Sallyport. Similarly, front wall camera, could you please put on exhibit 3? Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sallyport. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. And this is the way the camera worked in Canton. Thank you very much.
Okay.
And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left,
I like
at
also how now the
5:08
prosecutor's introducing
a.m.,
evidence from outside the case.
that taillight part was already missing. If we look at Exhibit 6,
That's
please.
interesting.
And this is from the Ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sally Port video is relevant to show a break or planting of evidence. As Miss Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in two spots so you can get a clear look of that rear tail light missing. Forward, please.
I'm looking right at it.
Thank you. And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone.
Whoa.
And the reason why you see
Stop. Emergency timeout. Emergency timeout. Wait a second. No, I'm really confused now. Wait a second. What exactly are you arguing? You're arguing that the taillight was busted here? And if it was busted here, then it can't have been busted at 34 Fairview. Because it can't be busted twice, right? So are you trying to say it was busted here? I'm confused. I'm confused. Is this video supposed to be after the murder already happened? Is that why that makes sense? Or I thought this was supposed to be before. Oh, wait, no. They're saying this is after the murder happened, right? Okay, so they're saying in time this is after the murder happened. They're saying that this is like when she went back out the second time, right? Okay, so that's how it makes sense from their point of view. Okay, all right. I was confused there for a second. I was confused on the timeline. All right, carry on. Sorry, we can end the emergency because I was so confused there for a second. All right, carry on.
A red taillight cover and
All right, so the idea here. All right, so this is. Let me make sure I understand the timeline correctly because I was confused there for a second. So the state's theory is this is after the murder happened. She is going back out, and her taillight is already busted here. So obviously it can't have been busted at the Sally Port. That's what they're going with, right? Okay. All right. So if that's what they're going with, that makes sense. All right. That sort of makes sense. I want to go back just this frame or two because I want to see this again.
you can see the white light shine. Stop. You can see it clearly missing. You can't plant something.
I mean, maybe it's more obvious in the room, but I don't know that I would necessarily say that it's clear in that shot. I mean, I see what he's saying. I see that there's a part of the light that seems to be different, right? Because there's that red on. If we look at the right hand side, you got the red of the light on the left, and then you got a little bit of red to that right, and then you got sort of a middle part that appears to be potentially more white than the other parts. But I don't know, sitting here looking at that, whether or not I can say that that's due to just I don't know that I can tell that's a different enough, right? If you just showed me this to me, I don't know that I could say that that's different enough that I would be able to say for sure that, oh, there's a piece of that taillight missing. I mean, can anyone else see for sure? Because I'm trying to interpret this as fairly as I can. I really am, but it's such a minor difference. It's really hard for me to tell that it really means anything. I don't know. Maybe it's just me. I'm having a tough time with that one. Is it just me? And it's just, I'm just having a tough time telling for sure.
That's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white.
I mean, it could be that. I mean, I'm not saying it's not. I'm not saying it couldn't be that. It could be that there's something missing there, and it's the white shining through it. But I'm having a really hard time telling the difference between those two, man. I'm having a tough time, man. I guess the only other way it makes sense is if you compare it to the left-hand side of the image and you see that left tail light, right? The left tail light does seem like that more uniform color, right? There's just a uniform, and there doesn't seem to be like any break at all in that left. But on the right, there does seem to be a break on it. I mean, there's something that seems like it's going on there, but it's so hard to tell. It's just hard to tell for sure. Yeah, I don't know.
The defense position is also contradicted by the ARCA witnesses.
Is it?
If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th?
It's also after she backed into the other car. I couldn't really say for sure, but to me that looked like nothing. You know, that looked like a bump. Cars do what cars do, I suppose. But, you know, if you asked me from watching that video, I would say that no damage occurred to either car. I'm not saying it's impossible, but that looks like something that like no damage would occur. It's just like gave you a little bump. It's like, you know, so I don't know, but maybe, I don't know.
Says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from the review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there is one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by
What damage to the taillight, though? The damage as we finally saw it at the end? I mean, I'd agree with you there. The damage that we sort of saw in the end with like basically all the taillight piece being missing, yeah, I would agree that that probably did not call that. That seems logical to me. Okay.
dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up to the court, please. If you compare the right side to the left side.
Okay. That might be one of the funniest things that just happened in court I've ever seen in my life. This might be one of the funniest things I ever have seen ever happen in court in my life. He opens the image software and he gets a pop-up that says, edit your images using AI. Outstanding.
Although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dayton said, just like the 508 ring video shows, is missing. Is missing. There's no plant. The defense's position.
It looks like you're trying to frame Karen Reed. Do you want help? No, I don't want help, Clippy.
Also contradicted by the alarm.com video that we received pursuant to Rule 17. There are two videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Dayton in the driveway. The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. What are they stopping for? We can play video 9. And this is when the car is being put on the tow truck before it makes it to Canton. And just like 508 in the driveway of Meadows, John O'Keefe's home, you will see that right taillight, 9 white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
We cannot.
Yeah, you can't lower it. That's all the camera captured. No, Bev, we can't lower it. That's what the camera captured. No, Bev.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay.
If you look at it on a small screen.
Yeah, I mean, that to my mind is a lot more white versus red. I mean, that I would say that's more white versus red. That's fair. So it does look like it's hard to tell from, the image how much of the thing is missing, but that does look like a cleaner contrast.
You can see right there.
I do see it.
Yep. And then you'll see it.
But it looks like it doesn't look certainly as much as we saw in the Sallyport video, right? Because in the Sallyport video, I mean, it's basically the entire taillight's been missing. Here it's just this little tiny piece in the corner that's missing, or that's all I can see, right? So it's not clear that this is reflective of what we saw in the Sallyport, because here it's just like, basically, if I had to estimate, I'd say, maybe a sixth of the light is missing in the corner or something, as opposed to the entire light being gone.
Again. So the alarm.com video contradicts the defendant. Anything exculpatory.
Lexus LX 570 has white on the taillight? Not unless it's reversing, it doesn't. That would be illegal. It can't possibly have white on the taillight, not unless it's reversing. That would be illegal.
About these Sallyport videos. In fact, this whole idea of third party or plant doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the Sallyport video, that there's any type of is from herself. Ms. Reed spoke to her boss on June 20th, 2023. And in that testimony,
it is reversing when you see it light up. I mean, that's what's supposed to be, but it doesn't look like the car's reversing in this footage. Like, it looks like the car's being driven forward, not reversing. So it doesn't look, I mean, we can't tell for sure, obviously, but there's nothing that seems to strongly indicate the car is in reverse.
Can you stop the video at the important points? Please do so.
Yeah, see, the car's being driven forward.
Can you lower it?
The car's driving forward. Right.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light in this video. I cannot see it clearly on the screen.
So will you give me a flash drive of?
Yeah, see, the car's being driven forward. It's not in reverse. Well, yeah, the car's being driven forward, not in reverse. So it can't be white because it's in reverse, and it can't be white because of the brake lights. And the only way it can be right, the only way it could possibly be white is because the lens cap is missing, and so the bulb is just peeking through, right? Because it's not in reverse. So, yeah, it must be the part of the lens cap is missing. Looks yellow. Maybe it's yellow. That's possible too. Could be yellow instead of white. That's fair. I can definitely. It's hard to tell for sure, especially on this shot, that it's white. I mean, it's definitely in contrast with the red, but yeah, it might be. It could be yellow. That's possible.
All of these exhibits?
Oh, there we go.
Okay.
If you look at it on a small screen, see right there?
I do see it.
Yep. And then you'll see.
Although to my mind, it does look more white than red, but I mean, it's hard to tell for sure given this image, but it seems closer to white than yellow.
See it again. So the alarm.com video contradicts the defendant. Anything exculpatory about these Sallyport videos. In fact, this whole idea of third party or plan doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the Sallyport video, that there's any type of is from herself. Ms. Reed spoke to her boss on June 20th, 2023. And in that testimony, or in that interview, she said, I was seized, there was a pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry.
You know, it seems normal, the effing cops taking pictures before they tow the car, or the tow truck guy taking pictures for his own liability. Yeah, that's somewhat amazing that the tow truck driver didn't take photographs of the car. Yeah, that's a little weird.
Look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. There should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen. But it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the Sallyport, so there can be no plan. That is my argument regarding the Rule 14 issue.
That's actually a pretty good argument. I'm not going to lie. It's more than enough for the judge to rule in his favor. It's more than enough to rule in his favor. And I mean, and incidentally, by the way, like, you know, as I said anyway, like the remedy was always sort of a thing anyway. So yeah, I mean, I probably wasn't going to give it to Miss Reed in the first place, incidentally, under the relevant legal tests. And as to whether or not this evidence is exculpatory, he's making a pretty reasoned case, unfortunately, that it's like, no, this evidence reflects that, you know, the light was already missing. And so that's what the evidence shows. It's like, and he's got some, he's making a reasonable argument. He's making an argument that no court of appeals would reverse him on. If the judge made that the rationale, no court of appeals would reverse. So it's more than enough legal cover for her to roll against the defense if she needed it in the first place.
I'd like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make, because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen. Because of the collateral consequence of tampering with the jury, it would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion dismiss. It's not just a motion dismiss. It's a motion.
I tell you what, man, if somehow the prosecutor, and because it's a different trial and we're going to have to reevaluate it on its own terms. If somehow they walk out of this thing with a better case than they did the first time, that's going to be a really interesting day for me personally. I'll tell you what. That's going to be a very interesting day for me. Because obviously we don't know what's going to happen. We can't possibly know what's going to happen. But it'll be a very, very interesting day if somehow we get to the end of that second trial and my position on like Karen Reed's innocence has changed in a way. Potentially, who knows what could happen. But it's like, it'll be really interesting if somehow we wind up at the end of this thing and the state's case is more plausible than it is right now. No, that'll be fun.
To dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so, how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now it's important to see or hear or read what is said. because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning. Not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked, there have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question. One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question. Is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively, the next step is they have to identify our target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts.
Well, that's not a high bar, though. So he's marginally competent and reasonably honest. He's the best.
After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation.
Okay.
But it happened. When you look at the motion,
Fanning is beyond reproach is what we're going with. Okay. Jordan Patterson, $1.99 says, then why was in the Proctor group chat? And more to the point, why didn't he discipline Proctor and all the rest of it? Yeah. But his integrity is beyond reproach. Okay.
Filed by the defense in this case, and they found their target in Lieutenant Fanning. You look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They try to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with.
Like what?
They concluded that these complaints were not sustained.
So,
Wait a second. What strong measures did they take exactly? What strong measures did they take? Did I miss a memo? I'm confused.
we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community. We're going to pile in here in less than a month.
I mean, I will concede to the Commonwealth that those are quite aggressive statements, right? I mean, it's like, yeah, that's a problem. And there's a U.S. Supreme Court case that seems to strongly suggest it's a strong problem. So yeah, that certainly got my attention. And, you know, I will concede to the Commonwealth this much, right? If the defense went outside the bounds, right? If they made unreasonable conjecture, if they made an unreasonable conjecture and that prejudiced things, you know, to be fair, that would piss me off as a judge too. That would piss me off too. So, I mean, fair. You know, if you're going to start making those kinds of representations, you know what I mean? You know, that's a lot.
I give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact: Lieutenant Fanning was not in charge of juror security. Fact: Lieutenant Fanning did not have control of the jury. Fact: Lieutenant Fanning did not access the jury. Fact: Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact: Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact: at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror.
Well, he did look at a juror when he reported that juror's misconduct. Didn't he do that? So, I mean, he did look at least one juror because he said that juror was doing some bad and then reported to the court, did he not? So there was that.
Fact: no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact: Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact: Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper.
If he heard the information, then why didn't he ask whoever it was to report directly to the court? Or I'm confused about that a little bit, but okay. So he merely heard it and just relayed it. Okay. All right. Isn't that hearsay? Well, not for the purpose of an investigation, no. I suppose, but it's fine. You know, that's fine. We're not, yeah, it's fine.
And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror. Your Honor, these claims in the motion to dismiss have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
All right. I mean, I have to concede that was actually a pretty good argument by the Commonwealth. That was a pretty good argument by the Commonwealth. It does make the defense look pretty irresponsible, to be quite honest, in this. They've made a representation that this guy was, in charge of the jury, and the prosecution just came up and be like, no, not really any of those things. And so I fear what's going to happen now is the defense is going to get up and be like, well, we reasonably surmised, or we reasonably thought that, given that he was in control of this multi-thing agency, it was 6 degrees of Kevin Bacon is basically what the defense is about to do. 6 degrees of Kevin Bacon is not going to cut it, right? If what they're going to do is they're going to stand up and say, hey, we heard that he was in charge of this multi-thing agency, and he knew a guy who knew a guy who knew a guy who was in charge of the jury. Therefore, he had influence. No. So I think the defense is in trouble. So let's see what they've got.
If I may, Your Honor.
Yes.
Thank you.
And it was Jackson who said this, right? Because it was Jackson in that interview, right? Yeah, it was Jackson in the interview. I know it was. I remember seeing the interview. So the probability of Jackson getting kicked off the case just went up substantially. Yeah. That's what just happened just now. Yeah. Yeah.
I'm going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. These words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts.
Okay.
Which he very dramatically stated in just a second. Because this is a fact-based inquiry.
It sure is.
He asked for, standing right over there at sidebar, and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that.
Amber Ann, has a juror said there was interference? It doesn't matter. At least the way I read that one U.S. Supreme Court case, although it was slightly worse in the U.S. Supreme Court case because you actually had cops who were witnesses who were then put in charge of the jury. So it was like one step worse. But the U.S. Supreme Court basically said it's so prejudicial that you just no, right? So you don't actually need to show actually any interference. You don't actually need to show anything, right? If the cop was put in charge of the jury, game over, man. Game over, right? Stop asking questions. So it is so prejudicial that we can just stop asking questions. And that's one of the reasons it's such a big deal.
Recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers that are populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort, officers, which we haven't. He also said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, the greatest guy on the face of the earth. I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him? We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen, when somebody else identified him. It wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal.
But you made statements to the press. Was that before or after it was removed from seal? That would matter a lot. That would matter a lot.
Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case.
He didn't name Fanning in the press interviews? I seem to remember him saying something like that. But I could be mistaken. Maybe my memory is going. Maybe he didn't say anything about that in the press interviews. So yeah, maybe it matters what he said, or it could get into that too. I don't remember using his name. He didn't necessarily need to use his name to talk about him, of course. Right? You can talk about someone without mentioning their name. So if he described the person in a way to identify them, that would be sufficient. Or otherwise, like said, if there was a way to identify who the person was, would be sufficient, right? We can 2 and 2, right? We don't want lawyers to be too clever. So yeah. Yeah, so it could get down on exactly what was said by whom and when, all the rest of it. It could absolutely get down to that.
It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc.
And incidentally, by the way, it wouldn't even really necessarily have to be the person. Even if you couldn't identify the person, like from the statement, it doesn't necessarily have to be the person, because what we're really fundamentally talking about is like a person that would have a person that would be improper. So like, even if you couldn't get down to the guy from what he said, if he made a statement that would indicate that it was somebody, perhaps unidentifiable, but somebody like from the Massachusetts State Police or otherwise, that, this was corruption, right? That would even be sufficient, because it's not about the guy, really. We're not really impeaching the guy. We're sort of impeaching the system, right? And so it doesn't necessarily even have to be the guy, just so long as it was, essentially, in so many words, like there was a cop in charge of the jury who shouldn't have been, and that was bad because it led to, influence of the jury. Like even something that vague would be enough to create a problem, so you don't even necessarily have to get down to the guy.
When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before. The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss, is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning.
That's a reasonable question. That's a fair, reasonable question. Although it's unduly speculative.
Described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual courts security, the personnel security, the party's security to whatever degree that is necessitated, but maybe most importantly, the jurors' security.
No, this is a loser for me. This is a loser for me. Sorry, but it's a loser for me. It's 6 degrees of Kevin Bacon for me, right? It's like, oh, he was the commander and therefore he knew a guy, you know, something jury. Yeah, no, that doesn't work for me. No way, dude. No way. That is unduly speculative, in my humble opinion. That is unduly speculative and unduly reaching. And it is in this context is somewhat inflammatory, especially depending on what you said in the public. So again, it would get down to what he said in public would be more the problem than what he said in court, right? Because in a court proceeding, like that's one thing, right? Because like, okay, I'm just talking to the judge, which is a whole nother thing. So I'm sort of back to like, what did he say to the public and when and all that stuff. But the 6 degrees of Kevin Bacon thing is not working for me.
That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to was also the person that was in Miss Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet, we were denied an opportunity, Your Honor, an important opportunity, to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here, let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true.
No, you're going fishing, sir. You're going fishing. No beef fish for you. You have not made your proffer. Don't buy it.
But lo and behold, minutes before I stood up to give my summation, that juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right. There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sallyport video and how unimportant it is. How unimportant that video is. I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sallyport videos if you're investigating a bar fight. This was the purported murder weapon. This truck is the thing that the Commonwealth suggests was used to kill a cop. You think the video of it being pulled into the Sallyport might be of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality. But I do know this. I do know this much. There's one guy who thought it was important. The lead investigator. He pulled it all. All of it. He was super convinced it was important, and he's the guy that once pulled it, hid it from us for nearly 3 years.
That's better.
Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. And I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory. We've never, ever disputed that the light was cracked at 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety. Almost. Except a piece was still missing. There was a piece unaccounted for. There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick, in front of a jury, present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page and site number, but I remember it because I was sitting here. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played, is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of that.
I don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the grainy video showing, hey, look, some of these cameras are just grainy in other particulars as well, at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. That video he just played is at the top. That's the exact same video. If it's apples and apples, oranges and oranges, why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sallyport. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, Why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's
Good. Well, apparently you guys missed me. Apparently I leave and the trial crashes. If you leave me now, take away the very best part of me. All right.
I intend on remedying that record. There was also a conversation after with court TV.
All right, so provide it to Ms. Giannetti. Ms. Giannetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it, and he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor. You know, I would just note, Your Honor, you know, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. You know, it's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds. That,
you can take your time, Ms. Giannetti. You're not going to be 35 minutes.
Right. I certainly will not be. You know, this new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a cite, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly were just wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Ms. Giannetti's remarks, it wasn't in relation to 3.6, it was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide...
For your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It directly related to that point, not 3.6. But I will provide the videos. Mr. Giannetti is right, and the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Giannetti, but it wasn't in the fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
I'm so confused right now.
If you have the site, I'll give you until tomorrow afternoon to find the court TV site.
Very well.
If you have it, supply it to all, Ms. Giannetti. So I'm ordering the Commonwealth to, if they have that court TV site, to provide it to all of us. And if you don't, provide that as well. Provide that information. as
Thank
well.
you.
Thank you. All right, that's it for today.
All right. Well, okay. So that was interesting. So I guess we'll kind of do it backwards in terms of review. So the issue we last left, it really, to my mind, gets down to like exactly what was said and in what context, by whom and when, with what language. It's fact specific, as you might anticipate. And at this point, I'm a little confused as to the facts. I've been listening to this hearing like you guys, and I'm still confused as to the facts about who said what and when, and in what context, and so forth and so on. So was it merely said in court proceedings? Well, if it was merely said in court proceedings, then there's no reason for this level of outrage. It'd just be like, it would just be like your argument is not well founded, go away, right? There's no reason for outrage. The only reason for outrage by the court is if it was done in a non-judicial context that prejudiced the case in a way that violates the rules. And no attorney is allowed to make statements that will undermine the proceedings in public. We can make statements in court, obviously, but we're not allowed to really make statements to undermine the process in public. There are rules, man. We can't do that. So all the rest of it. So yeah. Anyway, so it gets down to exactly what was said by whom and in what context for me to understand this. So and it also depends, of course, what was on the docket and what was unsealed when. So like if we assume the defense made statements that implicate jury tampering by the government in a general sense, like, police officers who are not court officers were put in charge of the jury. Okay. So that's like the statement we're kind of looking for, right? It was specifically fanning would be, even worse. But if it were just like cops, not court officers were in charge of the jury, that would be enough to get my attention as the court. Okay. So if they made that statement in a public way at a time when that was not, when the docket was not released, so they made the statements, if they brought those statements into public in a non-judicial way, that would piss me off. Okay. That would piss me off. So that's what it gets down to for me in terms of that. Brennan did. Well, that would piss me off too, incidentally, if that's true. So you're so bad at this. I'm not bad. It's just hard for me to keep track of everything all the time. I'm sad. Don't hate on me. I'm just trying to be like, I'm a little bit unsure about something. I'm not bad. So that's what things are interesting. The defendant redacted in their motion. Okay, so if the prosecutor was the one who exposed it, yeah, I'm thinking aloud, right? I'm thinking aloud and trying to work through it. Exactly. I'm thinking aloud and trying to work through it. So if the prosecutor was the one who exposed it to the public, and after that the defense commented on it, then I don't think you can blame the defense, because then it's just like, okay, I'm commenting on something the prosecutor exposed. So you might potentially get mad at the prosecutor potentially for not putting under seal, if that's what happened. So if the defense put it under seal and then the prosecutor responded to it not under seal, and then the defendant made statements relating to that in public, then your ire would be towards the prosecution for potentially not putting it under seal. Yeah. So that's where the ire would properly lay, if it lay anywhere at all. So yeah. As to like the underlying allegation, so that's like issue number one, right? So that's one issue, is whether or not like the lawyers made a statement that prejudice is the case in a way that's in an extrajudicial way, like, then that's an ethics problem in addition to everything else. So yeah, so that's one issue. Then another issue is the allegation unto itself as it relates to court proceedings, right? So separate and apart from whether it was brought into public within the context of the case itself, within the court proceedings, then I'm not buying the 6th degree of Kevin Bacon. I'm not buying that. And as a judge, I'd be irked, although not apoplectic as I would be with the public thing, but I'd be irked at a bare minimum that a attorney was making such an argument based on such a flimsy conjecture. That for me does not work at all. Jordan Patterson said they went back and checked video, confirmed the inversion. I thought they deleted everything. I have questions. Yeah, I don't know about that, where this video came from. That part was unclear, but that's a reasonable question. How would the officer know about the juror? Because he was told by a confidential informant. That's what the prosecution said during the case, that this confidential informant, person unknown, went to Fanning of all people to report this potential jury misconduct, and then he reported to the court. That's what the prosecutor said. So yeah. All right, talking about issues from the Feb 27 article, Court TV titled "Read Motion Dismiss." I don't know what we're not. I don't know if we're talking about any specific thing. I'm just trying to lay out the parameters that I would want to judge this by, and try to lay out the parameters. So we're not necessarily talking about any particular article. We're just trying to illustrate how I would approach the problem. So getting back to this issue of relating to Fanning, I think it's way too speculative. I think it's way too conjectural. So I don't buy it at all. You can't just say Fanning was in charge of overall security, therefore something jury tampering. That does not work for me. That does not work for me. And so I would be irked as a judge very strongly if that was made. It's like, I'm going to need a lot more than something, right? I'm going to need a lot more connecting the dots. There's a video clip in the article that only partially answers parts of my question, right? The video clip in the article would tell me like part of the story, but it doesn't give me enough information. We being the Commonwealth, there's a video clip in the article relating to what the Commonwealth did. Is that what you're trying to say? There's a video clip in the article relating exactly to what the Commonwealth did that answers these questions. I'm happy to view it if it does. Is that what you're trying to tell me? Bev needs to be removed. Any other judge would have stopped all this nonsense long game, make rulings and nip it in the bud. Fair. So anyways, all right, so that's that issue. Then going back to the motion to dismiss, I sort of sit where I started, right? And we heard this sort of same thing in the Baldwin case as well, right? So Kurt, I think he was saying he didn't do anything wrong with accusations because he was told Fanning was in charge and not told he had no contact. So he didn't do bad ethics. Yeah, but you can't go from Fanning is in charge to a suggestion that the jury was tampered with because of, someone who was in charge of the jury. Why was Fanning even there? To run security for the trial. They told you why. Did Fanning dispatch an informant to mingle with the jury? Don't know. We don't know the answer to that question. We don't know the answer to that question. So with respect to the motion to dismiss, then the issue is, we heard about this in Baldwin as well. So first of all, we start with the prosecution and the Commonwealth more properly, the government as a whole. Yeah. Is too muddled to even understand what's being argued? Fair enough. He avoided the word tampered. He said interfered. That's not enough for me to draw a difference between. If he said interfered, I would have the same problem. That doesn't solve the problem for me. Do I think it's bad optics or conflicting interest considering Proctor? I don't know. I don't want to think about that right now. So with respect to the issue on the motion to dismiss, he's at a bar with the juror hearsay. Hearsay is an evidentiary rule for trial, not a rule just generally speaking for like all purposes. Cops do hearsay all the time. There's nothing wrong with it. Cops hear a thing, they report a thing, they investigate based on thing. Hearsay is not a problem with respect to investigations. It's not even a problem necessarily with respect to reporting things to a court. It's not part of the trial. It's not an evidentiary question. It's a separate thing. So with respect to the test of the motion to dismiss, the Commonwealth, the government, has a duty to disclose any information in its possession that would tend to suggest that the defendant either didn't do it, that the defendant shouldn't be punished as much as they would otherwise be, or tends to impeach any witness relating to their case. They have a duty to disclose those things. Okay? So that duty has no particular mens rea, right? It's just a duty that exists. And if you don't do it, you fucked up, right? So it doesn't require any specific showing. All right? So that duty exists. Now, in terms of the violation of that duty, what do we do about it, right? Then we get into this idea of an intentionality being an element of that. And we heard that as well in Baldwin. So the intentionality, purposefulness, bad faith of the prosecution or the government as a whole, potentially, but typically the prosecution, will be a factor that will suggest a dismissal. It doesn't necessarily require it, but it suggests it, right? So with that bad faith, intentionality thing, then it would suggest, but not necessarily require, dismissal. So that's why it was relevant, or well, that's why they were talking about it. Okay. And it is the judge in this context that's the finder of fact, because we're not the jury. The jury finds facts with respect to the guilt of Karen Reed. That's what they do. But the judge decides facts outside of that context that are relevant to the case. So, for example, did the Commonwealth act intentionally in not giving evidence to the defendant? Has nothing to do with whether or not Karen Reed is guilty, right? Unto itself, it doesn't. Because the Commonwealth's failure, even their intentional failure, doesn't change whether or not Karen Reed is guilty or not, right? It goes to a different question. So the finder of fact in this context is the judge, because it doesn't relate to, did Karen Reed do it? It relates to, did the Commonwealth fuck up their obligation, which is a different question. Okay? Mass is different than New Mexico rules to some degree. Of course, that's true. I was just comparing because they're not like worlds apart. There's differences, but there's also commonalities. So I was just trying to point out that there's a situation that's comparable that you might have heard about. Okay. So in terms of intentionality, right, the reason in Baldwin that they were able to get to intentionality was in no small part due to the prosecutor themselves saying, hold my beer, and take the stand and be like, yes, I was involved in the police when they decide with the thing that came in. I was involved in deciding how it got filed. And I basically directed the police to file it in such a way that it wouldn't be discovered by the defense, right? That's basically what happened in Baldwin. The prosecutor's like, yep, I did it. I decided to direct the police to how to file it so it wouldn't be discovered by the defense. I did that. And so it's like, oh, the judge is able to find intentionality because the prosecutor's basically admitting to it on the stand. And it's like, yep, that'll do it, right? That'll do it. So, but there's nothing like that here. There's nothing like that in this present case. There's nothing really that suggests intentionality from its own facts. Now, you might be able to infer it to some degree because they keep discovering new evidence, right? It's like every day a new piece of video, a new piece of evidence, so you could potentially infer it, but there's no like smoking gun really like there was in Baldwin with that element. And courts generally speaking, and I imagine Aunt Bev is going to be in no particular difference in this respect, courts in general do not like to find intentionality. They're more willing to ascribe to ignorance rather than malice, which isn't a bad rule incidentally, right? It's more likely ignorance than malice. So they're not likely to find it here. And in the absence of that intentionality, they won't get it. Even with that intentionality, they might not necessarily get it. But in the absence of it, they definitely won't get it, right? The remedy typically is you just get another trial. You just get another trial. That's typically the remedy. It's like, okay, you have the evidence now. Here it is. You get another trial. Try again. So that's typically the remedy. And we obviously have another trial because it's already scheduled. And to the extent that you have questions relating to any of these things, you, of course, can cross-examine the witnesses. So he's like, well, we'd like an evidentiary hearing so we can ask the questions. Well, there's nothing stopping you from asking the questions during the trial because the questions are relevant to the trial. So you can ask them then. So there's no reason to have an evidentiary hearing, right? There's no reason to do it now. So, yeah, all that stuff. So the motion to be dismissed will not be granted. That's where we sat on all that stuff. So that is the summary of the case as it exists today. And I was also going to go back to Twitter and see whether or not there was any more discussion relating to this federal court proceeding. Because if there is, I'd certainly like to read other people's account of it and see what other people were writing about it. So let us go back to Twitter and see if we can find anything. I love you, man. Thank you. I appreciate that. I try really hard. All right. Karen, Reed. Let's try federal and see if that helps at all. Yeah. Why can't the U.S. attorney tell us directly that the federal investigation is over? The short answer is they can't because of DOJ policy. The long answer is why they can't tell the public directly. They can inform third-party law enforcement of the status and permit them to release information, thereby avoiding policy. Yeah, that makes sense. So. I believe the investigation's over. This is an overstatement, by the way. This is wrong. For all the trolls, we can always correct people in the wrong. So Officer Jack me off, cute. For all you trolls out there doxing expert witnesses in the Karen Reed trial, remember one thing. It's in fact illegal, and ARCO experts are not just witnesses in Norfolk County. They're federal witnesses, and that makes it a federal crime. No, not inherently it doesn't. Not inherently it doesn't, right? So it depends on the nature of their role. So no, but it's not necessarily automatically a federal crime. They are in fact federal witnesses, but it doesn't necessarily mean you're interfering with them in that context. You might be, but you might not necessarily be. It's not necessarily a given. Things get fun and complicated. What else we got? See if there's anything else on Twitter relating to this. Yeah, and what people call doxing isn't necessarily doxing nor illegal, right? That too. Yeah, that too. Fair point. All right, so we read J.M. Lawrence's thread earlier. Yeah, it looks like J.M. Lawrence was the only one that had notes from this morning. So fair enough. Cool. So yeah, I still think I sort of lay the odds exactly where I left them before, although it's interesting that apparently the judge in the federal case didn't seem to ask any questions relating to the issue of consent/waiver, which is interesting. If the judge thinks that that's, if the judge thinks that that's not an issue, that's interesting to me. We'll see what we can do. We'll see what we can do. Maybe someone will pay for a transcript of the hearing. That'd be fun if we could get a transcript of it. I think technically I could pay for it, but I think I'm not even sure technically whether or not I can or not. But yeah, but if there's a transcript of today's hearing, that would be really fun to read that. That'd be really fun. But it would probably cost me like some significant money that I don't have to get the transcript, assuming I can at all. Okay. The Commonwealth laid out consent and waiver stuff in rebuttal pretty well. How do you know that, Matthew? Because we were trying to read, like, is there other descriptions of the case from this morning? I mean, if you mean in their pleadings, they did, but I was wondering what was discussed at oral argument because I'm interested what the judge was interested in, obviously. Because that way I can better assess what the probabilities are. No federal court proceedings for me. That's sad. Yeah, not privy to the hearing. Is there any good reason for federal courts to be this secretive? They're always this secretive. That's what they do. That's what they do. That's what they do. That's just a normal day in federal court, man. That's what they do. I could send the court reporter an email and see how much it would cost me to get a copy of this hearing. I guess I'll send him an email and ask. It can't possibly hurt to ask. The number is going to be way more than I already know. The number is going to be way more than I can possibly spend. But I am curious. Maybe we can crowdfund it or something. I don't know. It could be $300 and I wouldn't be able to spend it. All right. Well, I don't think I have anything more to talk about right now. So if there are no more questions, I guess I'm going to wrap up the stream. What's the rate? 75 cents a page? I don't know. I'm not sure. It depends on like how fast I need it. Okay, readings. Is it possible for me as a member of the public to get a transcript of the hearing if so, what would be the cost? Thank you. All right. All right, great. All right, so I guess I'm going to go ahead and sign off for now. I've been on civil law. Until later, we'll talk. Hope you have a good one, my friends. Until later, my friends. We might be on later today, possibly doing a Supreme Court oral react. So that's still possible today. Is there court tomorrow? Does anyone happen to know off the top of their heads that there's court tomorrow in this case? I seem to vaguely remember there was. Oh, wait for chat to capture. No court tomorrow? Okay, cool. All right, so in that case, I'll probably do the Supreme Court thing tomorrow. Give myself a break. And I'll do the Supreme Court thing tomorrow. All right, that makes more sense, I think. All right, cool. All right. And we'll cover other stories as things happen. Turtle Boy has court? Yeah. I don't know. Yeah, Turtle Boy, I don't know enough, and I really don't want to learn enough, to be honest. I don't really want to get into the Turtle Boy stuff. So I don't know, and I don't want to figure out whether or not there's liability there. Someone else can figure that out, to be quite honest. I'm deep enough into Karen Reed lore as it is. I don't also need Turtle Boy lore floating around in my head. I don't have the space. I don't have the space. You know? So I don't know whether or not there's evidence against him or what the probabilities are. I don't know. I don't know. All right, guys, I'm going to sign off for now. I hope you have a good one. Bye-bye for now, Lord.